That's us now live, Chris.
Thank you. Okay, good morning, everyone. This is day 10 and the final day of the Sanquhar 2 wind farm inquiry. So today is hearing session 2 in relation to proposed conditions and the potential need for legal agreements in the event that consent is granted for the wind farm. So again, there are one or two new faces or names on the screen. So by way of introduction, my name is Christopher Warren. I'm a reporter from the Scottish Government's Planning and Environmental Appeals Division, the DPEA, and I've been appointed by Scottish ministers to hold this inquiry. So, and for the benefit of those of you who are joining us for the first time, I just need to point out that this hearing session is being live streamed on the DPEA webcast site, and a recording of each day's proceedings can also be viewed there. So by participating today, you're consenting to the recording, storage and use of this material for webcasting, training and for the keeping of records that are accessible by the public. Can you hear me clearly? Yes, no problems. Good. We might end on a high today, let's see. So I need to now confirm who's taking part in this session, please. So for the applicant, please, Mr. Hardy.
Then, sir, it's going to be myself and then assisted by Mr. Keith Campbell from my instructing solicitors as and when that's required.
Thank you. For Dumfries and Galloway Council, please. You're muted, Mr. Armstrong.
Good morning, sir. Douglas Armstrong, and there'll be Peter Ferguson for our partner Harper McLeod and Andrew Robinson from the Planning Department.
Great, thank you. And for East Ayrshire Council, please, Mr. Wilson.
Morning. Yes, it's David Wilson, the Interim Operations Manager for East Ayrshire Council. Will be myself.
Thank you. And for Glasgow Prestwick Airport, please, Mr. Brown.
Good morning, sir. It's
good morning.
Ewan Brown for the airport, and I will be presenting the airport's position myself this morning.
Thank you. Is there anybody else on the call who was expecting to participate today, but I haven't given the opportunity to introduce themselves? No? Okay. So I've not issued an agenda for this hearing. As I've previously indicated, my intention for this session is to work through the draft conditions proposed by the applicant and the proposed amendments and comments raised by other parties. So we'll take each condition in turn. The applicant circulated an updated schedule yesterday afternoon, which made changes to the wording of numerous conditions in response to other parties' comments and matters discussed in previous inquiry sessions as well. So I went through this last night, and it looks like this should narrow the areas of disagreement. I mean, I intend to base our discussion on this latest document. Do you all have sight of this, and are you all happy with that approach? Yes? There'll be one or two.
Yeah, thank you. I mean, just I'm sorry that was late, but the idea was to try and capture all of the comments, and I hope that it has narrowed ground. The intention was to be helpful.
Oh yeah, no, certainly, yeah. I think it will be helpful. Yeah, thank you, Mr. Hardy. So there'll be one or two additional matters where I'd like to discuss whether a condition would be appropriate as well, but I'll come to that at the appropriate point. So, in terms of how we'll progress today, I'll lead the discussion. I'll invite you to all contribute at appropriate times, but I'd welcome relevant comments and questions from any participant as we look at each condition. If you have questions for another party, these should be put through me, please. Now, it would help me to manage our discussion if those of you who are actively participating could keep your video on and raise your hand when you wish to speak. It seemed to work well yesterday, so I'd envisage it should work well for us today as well. If I've missed you and I start to move on, please tell me. Again, we've got the whole day available, although I think it's unlikely to take all day. So we'll take a short break midway through the morning, and if we need to break for lunch, we'll do so at a convenient point as usual between 12:30 and 1. At the end of this session, I'll close the inquiry. Is everyone clear about what I've outlined? And does anyone have any questions or matters arising before we start to look at the schedule? Mr. Hardy, please.
Yes, not on the conditions, but I've got two preliminary matters that I'd like to raise. So I don't know whether if anybody else has any points on what you've said about the conditions. Maybe should we do with those first? I don't have anything to say on that.
Okay, I didn't see anybody else putting their hand up, but let's just.
So two matters. The first of those is you may have seen, I know you've been busy doing other things, but I think it was Tuesday, Glasgow Prestwick Airport circulated the results of the IFP assessment. I don't know whether you saw that. And
yes, I have.
Yeah, the bottom line is that there is no impact on where we get to is there is a minor infringement of two procedures and charts which are defined in the wider GPA Aeronautical Information Publication, the AIP. Now, we've spoken to Mr. Parkinson. Our view remains exactly the same, that doesn't provide any substantive difficulties. But I do think, in terms of completeness, that it would help to have a written note on that. Clearly, GPA may want to put in a response to that as well, and of course that would be acceptable. So what I'm going to propose, we're not being able to do it for today because Mr. Parkinson has been with his family on holiday in Cornwall, but he's back yesterday. So I'm going to ask that maybe next week or a 7-day period or whatever it is provided for us to be able to put a note in, limited to just dealing with the results of that IFP assessment.
Okay, thanks, Mr. Hardy. Actually, I said I'd seen it. I don't think I have seen that one. Actually, I was thinking of a different document that I'd been looking at. So, can I just check, Mr. Brown, has that been submitted to us?
Yes, sir, it has.
Okay.
But when I checked with my agents this morning, they hadn't received an acknowledgement, so it must be somewhere in the...
Yeah, it sounds likely that it hasn't come through as far as me yet. Then yes, because I haven't seen that. But on that point, Mr. Hardy, well, first of all, Mr. Brown, do you have any comments on what Mr. Hardy has outlined and proposed there?
Well, so far as Mr. Hardy's proposal is concerned, I've got no difficulty with that, sir, provided, of course, the airport, as Mr. Hardy indicated, then has a similar period in which to respond to Mr. Parkinson's comments.
Yes, of course.
Yeah, that would certainly be the case. Mr. Hardy, what time frame would you propose?
I've not spoken to Mr. Parkinson about his availability. I was thinking 7 days would be sufficient. So could we start with that? If we need any more, perhaps we could come back. But I'd have thought 7 days from today. So close the business next Friday, and then I don't know, 7 days, Mr. Brown, for the airport.
7 days for the airport. Sounds reasonable to me, Mr. Brown. Are you content with that?
I'm content with that, sir.
Okay, thank you. Yeah, well, that's fine, Mr. Hardy.
Very grateful for that. Second thing is in response to your question. Yesterday there was a question about the candidate turbine for the noise assessment, and that leads on to a couple of points which we can usefully discuss. So the noise, we've gone back to Hayes Mackenzie, who did the noise assessment. The noise assessment was based on an Enercon E138, which is a 4.2 megawatt rated machine.
Okay.
And the reason that candidate was chosen, I think they looked at a combination of both the Enercon E138 and the E115, which is also a 4 megawatt machine. That they are turbines which have got a sound power level output which is comparable to other turbines of a similar description. So it was chosen as a reasonable candidate turbines. There are other makes and models available, as they say, with similar sound power levels. The candidate, it isn't the noisiest, it's not the quietest. It was just chosen as being a representative example. And without getting into too much detail, there is a Vestas V150 5.6 megawatt machine, which has a maximum sound power level, which is very comparable to that E138. So it's basically as a candidate. In terms of immediately you would go, well, 4.2, that's not the same as you know, something approximating to 7 megawatts. Of course, what we're doing is deriving levels, so the levels are set. So whatever the final choice of turbine would be, it would have to comply with the levels which are derived from that turbine which has been assessed. So in a sense, if there's any risk, then that's on the in terms of curtailment, that then lies on the developer side, because you know, the levels are the levels. Those are the ones which will be set in the condition. But I just wanted to clarify that. And the noise condition you know, is set out. It's a standard form. We'll no doubt come back to that a little bit later on. I think it's also just worth confirming. So in terms of where do the what are the consequences of that potentially? Well, the LVIA assessment was based on a turbine with the full maximum parameters that are applied for. So Mr. Denny confirmed that. So there's no. Oh, you just.
I could hear you, but my video went off for some reason. Sorry.
you just went blank, but I think you're back. So just to say, look, there's no question of under assessment because Mr. Denny assessed in LVIA terms at all points a turbine with the full maximum parameters. So for LVIA purposes, he wasn't looking at the Enercon E138. He was looking at a candidate with the full turbine, with the full measurements. So the questions then about, well, there was questions about the 308 megawatts. How's that, you know, how's that calculated and how does that all fit together? Well, the figure is based on 44 7 megawatt machines, and that was based on the we're instructed based on a Vestas V150, which you can buy today, and that's a 6 megawatt machine. And what Vestas have confirmed to my client is that the generator within that nacelle has capacity to be increased to 7 megawatts. It's already, I think, been increased from a 4.2 machine. So the innards, if you like, of the machine can be increased to 7 megawatts. The direction of travel is in terms of improving efficiency, as a bit like other things. You know, in 2 years' time, Vestas are very confident that there will be a 7 meg innards to the same nacelle. So the assessment is 44 by 7, and I think it's worth just saying, in terms of development, what the client has indicated is that during the tender process, this is something that does happen because they've tendered before where they've gone for a 3.2 megawatt machine, but actually by the time the machine's been delivered, it's been uprated. The innards have gone up to 4.3, I think it was in that case. So it is just on the onward progress of technology is kind of ever upwards, ever better. So a 6 megawatt machine is available at the moment, and it'll be a 7 megawatt innard by the time of you know, the important point of being constructed. I think the final point, just to see how this washes through, is that the capacity could be more in terms of, you know, in terms of the overall output. Obviously, the more the better. When you look at the precedents for Section 36 consents, they are not capped in terms of an overall, you know, you're not putting a cap. They are developments of over 50 megawatts. Of course, you've also got to take account of the proposed storage, the fact that 7 megawatt may be conservative. So in short, I think the questions were coming about the what turbine was used for the noise assessment. How does that fit into the 308 question that we're looking at yesterday? It is 44 times by 7 megawatts, which we say is a conservative basis on which to have assessed the scheme and the benefits. So I hope that's helpful. We did the client did some homework on that question for you last night.
Thank you, Mr. Hardy. That is helpful. Now, I don't want to reopen the hearing discussion that we had yesterday, but I'd like to just give Mr. Armstrong or Mr. Robinson the opportunity for any response.
Yes, of course.
What you just outlined there.
Yeah.
So we've got no comments at this stage. Obviously, I appreciate Mr. Campbell is not here, and his I don't think there is a representative of
No, there's
group
not.
here today, and this would seem to be relevant to a number of the points that they were making yesterday. Not quite sure how they will be informed of this or whether somebody is listening in, but I think for fairness, they obviously need to know.
Yeah, I wonder, Mr. Hardy, whether it would be helpful in a similar vein to what you outlined in your first matter, whether a short paper could be circulated to give other parties who were participants in the first hearing session a chance to just comment on what you've outlined there.
I could do a sort of bullet point note, really, just in limited to what I've just said. I could certainly do.
That would be helpful, I think.
Could certainly
yes,
do
thank
that.
you. So if I could ask for that to the same time frame as what we discussed for
Yes.
for the airports paper,
Yes.
that would be helpful. Thank you.
I can. Thank you.
Okay. Are there any other points or matters that anybody would like to raise before we look at the schedule? No. Oh, Mr. Armstrong.
Sorry, I just have one matter in relation to closing submissions, but perhaps we could deal with that at the end of the condition session rather than the beginning, and because I think it's
as you wish. I don't mind you asking me now if you wish, if you prefer.
Well, I suppose it's only really relevant to some of the parties here, but it was just that yesterday, obviously, there was some discussion from Mr. Hardy about the relevance of, I think it primarily related to the evidence of the Stop Sanquhar 2 group, but it may just have touched on to issues that the council obviously advanced on Tuesday. And Mr. Hardy said that he would produce cases and submissions to support his submissions on relevance. I don't mind how it's done, but obviously, if Mr. Hardy is going to raise issues on relevance, I would, and I think it's a matter of fairness, like to have for the council an opportunity to respond. And I'd have thought Mr. Campbell would also, I think he also raised the issue of perhaps having preliminary submissions on these matters. I don't think we need to go to that stage, but could we write into the process, if Mr. Hardy is taking a point about relevancy of evidence, that there is an opportunity to respond to that? Because normally on questions of relevance, that would be dealt with by a preliminary matter, and parties would be able to respond. So can we write in that if Mr. Hardy is taking points about relevancy, then we should have fair notice of these points and be able to respond to them?
Well,
Mr. Hardy,
well, yes, I can respond. I think that point actually it isn't quite right. I'm very happy to say you could have all material consideration. I'm not going to take a point that you exclude evidence. I think that would be that's not what I'm saying. I'm very happy for you to take account of all matters and you attach weight, but the submission would be that you give virtually or de minimis weight to it or negligible weight. So I'll take that as an approach if that gives some assurance to the council. What I am prepared to do, I thought this was what was going to be asked of me, if there are any legal cases or any authorities that I'm going to rely on, then in the normal way I can notify my learned friends of those. I'm happy to do that in in the next 14 days or something like that. And similarly, if there are any legal cases that either my learned friends or Mr. Campbell were going to rely on, then would ask for the same courtesy. That's just standard practice.
Thank you, Mr. Hardy. Mr. Armstrong, do you have any comments on that?
Well, I'm obliged that Mr. Hardy's clarified his position from yesterday, and so I'm happy to go with that. I'm happy to also produce any additional cases within that 14-day, although obviously if Mr. Hardy is producing them first, I'd quite like to see what he produces to see if there's anything I want to respond to.
Of course, I'm happy to say if we say 14 days for cases, and then from myself, maybe there aren't any, but 14 days and then 7 days afterwards, so that I've got notice of the council and Mr. Campbell's legal authorities, if there are any, that would be helpful.
I'm conscious that might actually, I don't have before me the actual date for this closing submissions for
Well,
the council.
I thought that was the point that you were going to raise, Mr. Armstrong, which was actually Mr. Campbell was seeking to change the date for submission of closing submissions. So he, let me just draw up the email.
Which Mr. Campbell, Mr. Hardy?
This is Mr. John Campbell,
Okay.
not Mr. Keith Campbell. We're not seeking to do that. He emailed this morning and said he emailed Jane. Dear Jane, good evening. Thanks to Keith for the fresh set of conditions. Stop Sanquhar 2, nothing to add to what it says in the documents. Will there not be appear or be represented in the conditions hearing number 2 tomorrow? Stop Sanquhar 2 respectfully proposes that closing submissions for opponents of the scheme be submitted by Monday, the 15th of November. According to your timetable from the pre-inquiry meeting, I think that was the 19th.
Yes, it is.
So
Yeah.
he was seeking to change the date. He may have just made a mistake. I don't know, but it sounds as though he was proposing something which was different.
Right. I haven't seen that email, and obviously I can't ask Mr. Campbell myself now
No.
for clarity on that point. But in terms of going back to what the discussion was focused on in terms of legal precedents and so on,
7 days, I'm happy with it. I can do that again in 7 days.
That and then I think the 19th of November deadline for closing submissions from all the parties apart from the applicant is actually quite beneficial in terms of it gives us that window for that to then be wrapped up in closing submissions
Yes.
by all parties.
Yeah, I'm very happy with that. So it's 7 days really for all three things that are on the shopping list from us.
Yes. Yeah. Okay.
So I hadn't received Mr. Campbell's email, but I'd certainly be keen to keep it to the 19th of November. And I'm obliged to Mr. Hardy for suggesting he'll produce any additional cases in 7 days, and then if we produce any further ones within 7 days from that, I think that works very well. I'm obliged.
So
Right.
again, does somebody want to communicate that? I don't. All I'm doing, the email was widely circulated to people. I notice it's. I think it went to Mr. Robinson at the council. I don't know what was behind that, but is somebody going to communicate to him that actually that's not been accepted and the date is the 19th? Or
Yes. Well, if that email was sent to Jane Anderson, the case officer,
yes,
then
yes, it was.
Yes, so I'll no doubt receive that on Monday. I know Jane's on leave today, so
Right.
That's why it's not come through. So I shall respond to Mr. Campbell via Jane on Monday.
Thank you.
Okay, are there any other points anybody would like to raise before we look at the conditions? No. Okay, so making sure we've all got the most up-to-date version in front of us before we begin. So I'm going to look at them in order. So I think, so in terms of the Section 36 consent conditions first, the applicant has made a proposed change, which is highlighted in red in the right-hand column, which appears to address the point raised by Dumfries and Galloway Council. Mr. Armstrong or Mr. Robinson or Mr. Ferguson, are you content with that modification?
Sir, we are content with that modification. There is perhaps one point, it is to do with the conditions, but it's actually the glossary before we get to the
certainly
the first. And I know there was no dispute about this, and I don't think it's an issue that's going to concern parties. But on looking at, and of course, sir, you'll appreciate that the proposal straddles two authorities. And there's interesting issues in relation to potential enforcement and other issues because of that. And on looking at the definitions, and we've got the definition of planning authorities, means Dumfries and Galloway Council and East Ayrshire Council. And then we've got the relevant planning authority, and it's got means Dumfries and Galloway Council and East Ayrshire Council.
Yes, it should be or, I think.
I wondered if it might also be more logical to have maybe depending on the issue, either or both Dumfries and Galloway Council and East Ayrshire Council, because there are myriad of potential situations here, and it's just to try and I think it's good to have a definition of relevant planning authority, but I think perhaps to be a little bit more precise, it might be worthwhile having, depending on the issue, either or both Dumfries and Galloway Council and East Ayrshire Council. It's a minor point, but when we
question.
It's a minor point, but when we go on to the actual conditions, sometimes I think it becomes apparent that it's important to have that distinction.
I think that's very sensible. Yes, I was going to say or, but I'm quite happy to add on the depending on, depending on the topic or depending on the particular circumstances. So the definition would be Dumfries means Dumfries and Galloway Council, and stroke or East Ayrshire Council, depending on the particular circumstances.
Yeah, or depending on the issue or something.
Or depending on the particular issue, yeah.
Thank you. Yeah, that's a helpful point. Is there anything else on the glossary? Okay, so thank you, Mr. Armstrong. You've answered my question about condition 1, so I don't think there's anything else we need to discuss there. In terms of condition 2, now the applicant has amended the proposed commencement deadline to 5 years rather than the 6 proposed previously, which aligns with what the council and what Stop Sanquhar 2 had indicated. I've just got a question about that, Mr. Hardy. So this is a condition, obviously, of section 36 consent. Are there any implications of the 5-year period in terms of the deemed planning permission? And I'm asking because 3 years would align with section 58 of the 97 Act and the time limits which apply to deemed planning permission. So a longer period requires a direction to be made by Scottish ministers. So my question is, how would I address that point, or how would ministers address that point?
I think the justification for the extension would be to tie in with the section 36.
Okay. I think I need to make an express point
I think so. Yes, it's to make the shorter tie in with the longer rather than the other way around.
Yeah, because I'm not sure a condition itself is sufficient to address that need for a direction.
I agree. I think you need to make an express point about it.
Are there any other comments about the 5-year period? I'm assuming that that's agreed. Yeah, okay, thank you. Okay, Mr. Campbell had a point about a query about the non-assignation condition, but I think it was just a query. I don't think I need to ask you about that, Mr. Hardy. Moving on to condition 4. So the applicant, again in red, has, I think, provided the clarity that Dumfries and Galloway Council were seeking. Does that, Mr. Armstrong, does that, and Mr. Robinson and Mr. Ferguson, does that address your comment sufficiently?
It does. There was one issue which we thought perhaps relevant to raise at this stage, which would deal with condition 4 and condition 6. And it's really just a query or thought about why these are actually in the section 36 consent rather than in the deemed planning permission, and the reporting to the Scottish ministers, because inevitably on these matters, I suspect if there is a matter raised, it will be the first person will be contacted will be the local planning authority, and it will be either Dumfries and Galloway or it will be East Ayrshire Council. And we just wondered, was there a particular reason why it was in the Section 36 consent rather than in the deemed planning permission conditions? Because for these types of things, I mean, the question we raised, who would it be in the Scottish ministers that you get in contact with?
Mr. Hardy, what's your view on that?
Yes, no, I mean, I think it's not a great, I don't think there's a great deal of moment, to be honest. I'm not sure of the origin of it. It seems to me there is no harm keeping it where it is. It's a matter, I suspect, for you, sir, as to whether you take them out and put them elsewhere.
I wonder whether, okay, I wonder whether its origins are actually in the Heads of Planning Scotland model conditions for Section 36.
Yes, it is, actually.
They appear.
And what
that doesn't necessarily mean it can't be changed, obviously.
No, but it is that there's form for there, and what Mr. Campbell is saying to me is that is typical. There's a lot of examples of where these are in there, so that is the origin. I can explain. So I hear what's said, but I don't think there's any damage done by keeping it where it is.
I mean, so I think there are examples both ways on this, and we're just conscious of that the practicality of these things is that inevitably, if there's say, it's often the council that will be contacted first rather than the Scottish ministers.
Thank you, Mr. Armstrong. I'll give that thought. I've got a note of the point. On condition 4, Stop Sanquhar 2 had raised a query about whether it means any breach or a serious breach. I think any breach is perhaps more clearly defined than a serious breach.
I think our concern was that introduced an element of subjective judgment, and I don't think that is as precise. So would reject that.
Are there any other comments on that specific point? Okay, so then on to condition 5. So this is the NATS en route aviation radar condition. The NATS condition itself seems uncontroversial. Obviously, this then draws into question Glasgow Prestwick Airport's proposed condition, which it appears in the same row of this schedule. So just bear with me a second. Sorry, yes, Mr.
No, I was just going to say, so in relation to NATS, I don't think there's any comments from any party on that. Of course, that condition is in the terms that were requested by NATS to withdraw its objection. So
yes.
It is, we'd suggest that it remains in its unamended form. I don't think there's anything saying different. No,
I don't. Yeah, I think that's the case, and I'm not seeing anybody contesting that. Okay, so then in the third column of that same row under number 5, we have Glasgow Prestwick Airport's proposed condition in relation to their aviation radar interests.
Yes.
And then in the last column, there are 2 versions of the applicant's condition. So there was the condition that we saw and had in front of us during inquiry session 1 on page 4, and then towards the end of page 4 we have an alternative overleaf onto page 5. We have an alternative which addresses the kind of the what if question, if we put it as crudely as that.
Exactly.
But if I can turn to so Mr. Brown, in terms of the condition proposed by Glasgow Prestwick Airport, can I just clarify first of all, and I'll give you the chance to kind of say what you'd like to say about that condition. Is the wind farm mitigation agreement and the wind farm mitigation scheme 2 separate aspects of the condition? Can I just confirm that that's correct?
Yes, sir. The wind farm mitigation agreement would deal with the costs and risks element, which were discussed during the inquiry session, and how that was to be dealt with. And the scheme itself would deal with the technical, operational aspects as to how the mitigation was to be achieved.
Okay, that's clear. So then, in terms of under your proposed condition 1 part 1, where it requires the applicant to enter a wind farm mitigation agreement, would the applicant be able to do that without entering a non-disclosure agreement?
Now, sir, on that point, I would need to just take instructions.
Certainly.
If I may.
So while Mr. Brown's offline, of course, our understanding, the evidence at the session was no. That is one of the key points, that this is the sealed system that we spent a week talking about.
So that would ultimately be a matter for the board. I suspect Mr. Hardy is right in light of the evidence that a non-disclosure agreement would be required, but it's certainly something I would confirm with the board before submission, sir, if that would be helpful.
Thank you. So in terms of the proposed condition by Glasgow Prestwick Airport, could you say a little bit, Mr. Brown, about how this condition aligns with the requirements or the tests in Circular 498, please?
Yes.
Could you give a few moments if you
No, that's fine, sir. I'd actually intended to cover this in submissions in more detail.
It would be helpful, but I think it would be helpful to hear now as well,
Yes,
to give Mr. Hardy the chance to respond here.
Yes, sir. When looking at paragraph 2 of the circular, the tests are that obviously the condition must be necessary, relevant to planning, relevant to the development to be permitted, enforceable, precise and reasonable in all other respects. Now, looking at that, it's the airport's position that it's necessary and it's relevant to planning and relevant to the development, which is before the inquiry. It's enforceable and it's precise, it's quite clear what's required. And so far as the question of it being reasonable in all other respects is concerned, the airport would submit that not including the condition in the term sought would be unfair to the airport, since it would not properly recognise the costs and risks, which provide a mechanism for dealing with the costs and risks which the airport will incur for the lifetime of the development. As I say, sir, those are the headlines, and I'll be happy to develop those points further in submissions.
Thank you, Mr. Brown. Mr. Hardy, would you like to respond to that?
Yes, I mean, heard detailed evidence during the inquiry session, and obviously there are going to be submissions, but criticism really is as set out in the written case and cross-examination, and also Mr. David Bell's assessment of the condition, and to articulate some problems just in a proportionate way this morning. The developer couldn't commence development unless it's entered into a wind farm mitigation agreement with GPA. So aside from that point about NDA, I mean, the evidence is that there would need to be an NDA, but leaving that aside, there would still need to be a wind farm mitigation agreement with GPA. That is a separate obligation, I think, has been clarified to any wind farm mitigation scheme. What GPA is asking the ministers to do in imposing a condition as part of a statutory consent and public consenting process is to require a developer to enter into a contract with a private company before the developer can commence development. It provides, it's an express grant by a public authority of a veto, we say, It's nothing short of that over a development which had otherwise been granted consent to a private company, unless what became clear during the inquiry session, unless its commercial interest was satisfied. And all this is about commercial interest. And only if the developer were to agree with the commercial terms of GPA's wind farm mitigation agreement could you get on and build. To that extent, we say it can't be reasonable that such a condition is allowed to grant what is a commercial veto. I mean, in effect, talk turkey, it permits GPA to name its terms, and in the evidence during the session was that the only arbiter of what would be acceptable to the airport is itself. It's also just, I mean, a few other points, the wind farm mitigation agreement, the wind farm mitigation scheme obligations and definitions don't cross-refer. There's nothing to relate any payments under the wind farm mitigation agreements to costs under the WMS. And we say, in short, that it engages several of the condition tests. So necessity, referability to planning, precision, and reasonableness. So, I mean, in the strongest terms, this condition doesn't pass any of those tests, and you've got a sense of the force with which we'll be making closing submissions so during the week. I think by way of contrast, the applicant's condition, just to move on to that, I don't know whether you want to stop there or whether you want me to just go on and say why, what we're saying about the alternatives.
If I can just pause there for a moment, Mr.
Yes.
Hardy.
Yes.
Because Mr. Brown, would you like to comment or respond to what Mr. Hardy's outlined there in terms of his concerns about what you have about what the airport's proposed?
Well, sir, so far as the point about the airport having a veto is concerned, the evidence from the airport was quite clear that it's certainly not seeking to exercise a veto here, but it's seeking to ensure that proper recognition is taken of the costs and risks which it will bear as a result of permission being granted and the development being constructed. And of course, there's been no discussion yet between the parties as came out in the inquiry sessions about the terms of a mitigation agreement. And I would also suggest, sir, that given the various difficulties associated with the technical issues here and how mitigation should be provided and testing and all of these other matters, that the parties are actually in a better position to try to find a solution for themselves to these issues rather than the Scottish ministers. So, but beyond that, sir, I don't think there's more I can add other than to say that, of course, this will be covered in closing submissions.
Thank you, Mr. Brown. Yeah, I'm conscious we did discuss this at length during inquiry session 1 as well, so we don't need to go over the same ground. Mr. Hardy, in terms of the applicant's proposed condition and the two forms of it,
Yes.
would you like to say a little bit about that, please?
Yes, so the applicant, the condition that was proposed before the scheme, that's supported by evidence at the aviation session. That's supported by Mr. Parkinson clearly, but also most pertinently, you might think by Mr. Thompson. And it'll be no surprise when you get closing submissions which refer heavily to what was said by him in cross-examination. It sets out the actions required, referable are those which are referable to the proposed development, and requires payment of GPA's reasonable and demonstrable costs in respect of those matters. And that is what he said he needed to be satisfied on to put himself in the position to remove the technical objection, as you know. It also has, this is of limited benefit, but it's also got the symmetry with what was proposed by Scottish Power at SPR at Clockray. It doesn't make them, that's not definitive, but it's that was certainly the one of the intentions for there to be consistency. So that's what we say the evidence is demonstrates, reinforced by the table of the probability of detection, which you'll recall came in just after the sessions, but actually it was quite extraordinary. It was up in the 99% in some cases. So the idea that somehow we're going to be failing against the PD test, I'm afraid, is just not real world stuff. So we say you've got the evidence. That table nailed it in relation to the suitability of condition 1. However, if you were to say, yeah, what if, and that was the question that you raised during the session. Well, what if option 2 does give you some additional assurance by way of contingency? So we say it's not necessary, you don't need to go there, but if you had a lingering doubt, then option B would be suitable.
Thanks, Mr. Hardy. That's helpful. Mr. Brown, in terms of, now, obviously I appreciate, and I don't want you to, I'm not asking you in the context of accepting these conditions proposed by the applicant, because I fully understand that you don't agree with it. But if I was to form the view that the applicant's condition was more appropriate than that proposed by the airport, which of those two versions would you prefer, first of all, and do you think they cover the ground in that context?
Yes, sir. Well, on that basis, the second condition would be the preferable one, because that takes account of the concern that the optimization process might not work. But beyond that, sir, and again, I'm happy to elaborate this in closing submissions, but the headlines will be that the condition deals only with radar optimization. It doesn't look at the other communication, navigation and surveillance impacts. If there are requirements to amend the instrument flight procedures, that's not covered. It doesn't deal with any adverse impact on the instrument landing system, which can't be fully tested until the wind farm becomes operational. It doesn't address any impacts on the VHF radio. And the second tranche will be that it proceeds on the basis that only initial optimization is required. The third point which will be made is that the phrase that the sums are to be demonstrably and reasonably incurred leaves uncertainty. How is that test to be applied? And of course, sir, as I understand it, the scheme is that the undertaking will be put in place first, and then the costs are incurred. And then there could be argument after that about whether those costs were demonstrably and reasonably incurred, and who is to be the arbiter of that. So far as post-optimization flight trials are concerned, which is covered in lower Roman numeral 3, it provides that at the end, if such validation is reasonably required, well, of course, the airport's position on that is that validation will be required by way of a flight trial. But again, the use of the word reasonably required has the same perils attached to it as the phrase demonstrably and reasonably incurred. Again, how is that to be determined after the event? Who's to be the arbiter of that? And the other point, sir, and perhaps Mr. Hardy, through yourself, could clarify this point, but lower Roman numeral 5 provides the costs for providing to the developer and the Scottish ministers the results of all modelling, optimisation and/or flight trials in respect of each of 1 and 5 above. I was wondering, sir, whether that is the applicant saying that they will meet the airport's costs incurred, first of all, in terms of the manpower and so on, which the airport commits to ensuring these tests are done. And secondly, if that is the case, I would observe that it doesn't quite go far enough. I don't think that's clear enough to cover all of the work which the airport might have to commit to this exercise.
Thank you, Mr. Brown. There's a few points there, Mr. Hardy. Would you like to respond?
I'm not sure that I need to. I mean, it seems to me that what the airport is saying is it doesn't like the condition. That's fair enough, and we're not going to agree on that. The steps it will say aren't enough. We say that they are, and I think that respectfully, the condition is clear in what it does say. We say that is sufficient based on the evidence for you to be assured. So I suspect that there is the points really are substantive ones which aren't going to be resolved in a matter of drafting. They are what they are. You'll have to, unfortunately, make a form of view.
I mean, yeah, there are certainly some more fundamental disagreements there. In terms of the specific point around, so for example, the opening sentence where it says it will pay, there'll be a binding undertaking to pay the airport operator such sums as are demonstrably and reasonably incurred. If that, for example, if that was to say such sums as are incurred by the airport operator in, and then the steps that are outlined, would that, for example, would it make a substantive difference?
Yes.
Positively or negatively?
Absolutely, because the whole point is that, as you know, the airport is seeking to maximise. I mean, pull no punches on this. It's seeking to maximise commercial advantage, and so incurred gives it licence to seek to recover all sorts of things. It has to be tied back to the tests, and therefore demonstrably and reasonably incurred, I think, is a necessary control mechanism. And that's so demonstrably and reasonably relating to the items which are set out. So, and in turn, those are the only things which are referable to the development under the conditions circular test. So we say that control mechanism is required.
And in terms of who would be the arbiter in this sense, it would be essentially the Scottish ministers, I assume.
Well, it's
their responsibility.
Well, it's the airport that is deciding what is demonstrably and reasonably incurred. So, in other words, a place of binding undertaking to pay the airport such sums are demonstrably and reasonably incurred by the airport. The airport will have to do. I mean, it's going to be third-party work anyway, but it does what it says are, or it charges what it says are demonstrable and reasonable costs associated with those items.
I suppose my question there, though, is if the airport was to identify things which they consider to be demonstrably reasonable in that context, but the applicant doesn't, how would that be resolved?
Then that's the ministers. Yes. So it's in two stages. It's the airport to be limited to those costs which are demonstrably unreasonable. If there is then anything which is not accepted, then that will be a dispute which would go to the ministers.
Thank you. That's helpful. Mr. Brown, I'm not trying to reach consensus on this point, obviously, but do you have any final comments on that condition?
Yes, sir. Thank you. The other thing which occurs to me is my question for Mr. Hardy via yourself about what 5 is intended to cover. Lower Roman numeral 5 would be helpful to know, and I can pick up the point in closing submissions if need be.
Yeah, thanks, Mr. Brown. I didn't pick that point up when I was asking Mr. Hardy. Then, Mr. Hardy, could you answer that, please?
Yeah, I mean, what it says. So costs or providing to the developer and the Scottish ministers the results of modelling, optimisation, and/or flight trials in respect of 1 and 4. So any costs of not just doing the things, but the cost of providing the results of modelling, optimisation, and flight trials would be covered by the by that obligation. I'm not sure.
Okay.
It just is what it is.
Thank you, sir. I'll pick it up in closing submissions.
That's fine. Thanks, Mr. Brown. Okay, so we'll move on. So in terms of condition 6 on page 5, the aviation lighting condition. So there is a recurring theme here which might be helpful to discuss because it applies in terms of who should be responsible for essentially discharging conditions. It's a point raised by Glasgow Prestwick Airport here. I know Dumfries and Galloway Council have sought amendments which say in consultation with certain bodies. So if I could ask,
so
perhaps Mr. Hardy, if you comment on that general principle, and then I'll ask Mr. Brown and Mr. Armstrong to both comment on that.
Yes, I mean it's quite it runs through a number of the conditions, as you say.
Yeah.
We through my instructing solicitors sent a note through to you some weeks ago now as a preliminary point. Whether you recall that
Yes,
email, and effectively, I mean, it's a legal submission, I suspect, in truth, and it's this, that conditions can only be discharged. What you're trying to do with the condition is give the developer or oblige the developer to do something. So something which is under its control to do, and that can be submission of a scheme. It can be doing certain works, but beyond that, you can't. It is absolutely standard practice to have a condition limited to the discharging authority. So that's the statutory authority, the LPA, or the ministers, because that is the only party that can discharge the condition. So in terms of approvals, discharge, or whatever it is, it's only that authority that can do it. Now, it's up to the discharging authority, the statutory discharging authority, to organise consultation in the way that it thinks fit. There are obviously minimum consultation requirements, statutory consultees, and whatever else whatever else. But that body is the only body that can discharge, and it has to organise consultation in an appropriate way. So it doesn't need to be recorded on the face of the condition, providing a requirement that the developer can never comply with, because the developer can't force local authority to organise consultation with anybody. It's not something that's within its gift. Of course, the expectation is absolutely that the local planning authorities or the ministers will consult with all of the usual people, but it is not, in our view, appropriate to have those consultations named, or consultees named, on the face of the condition. And can I say this? And I've dealt with some examples before where there can be a disagreement, and it gets slightly tricky where you have very technical matters like aviation matters, because local authorities don't have expertise in-house. They can buy it in, I suppose, but they don't tend to have those. They don't tend to have that expertise. So you would expect them to go out to the airport concerned in virtually every case. But there can be disagreement. Give another example: the Environment Agency, or in England, or CPA, they have a view, but actually taken in the round, in terms of planning balance and discharge of statutory functions, the local authority thinks that it ought to discharge. It ought to be able to do that unfettered. And the problem with putting the consultee as a named party on the condition is that complicates the situation, because the developer is somehow forced to engage with that body. It shouldn't be put in that position, because the obligation to discharge is from the decision maker. So it's a fundamental point. And it's an important one, and I make it very firmly. But those are my submissions on it.
Thanks, Mr. Hardy. That's useful. Mr. Armstrong, please, and then Mr. Brown, I'll come to you.
Yeah, my lord, sorry. This is obviously, I think of next week. This is obviously an issue that applies to a number of the conditions. It does not put an obligation on the developer to contact, in this case, CAA, or in the other cases, SEPA, and it doesn't put any enforcement obligation on the developer in relation to that point. It would be for the Scottish ministers, or in the case of the planning authority, to then consult with CAA or SEPA or the other organisation. And if I could pass over to Mr. Robinson in relation to this and the standard practice, in relation to these types of conditions and why it is appropriate to have such a requirement, such a consultation process, should I say, set down in the condition.
Yeah, certainly.
Yeah, the council and other authorities add this requirement in mainly for some precision with the condition, so it's clear to all parties who is required to engage in a particular condition, and where these factors, or where this arises, is in particular we can get situations where a consultee will specifically request a condition. So, for example, SEPA will often request like a peak management plan and will wish to be consulted on it. So what we tend to do with that is we refer to that body within the condition that they are required to be consulted, because it's a condition that's really been required by them, and they are the experts consultee who would advise the council on the suitability of that. It actually puts an obligation on the council to consult that consultee, and it's also it makes everybody aware of who needs to be involved in that condition. Obviously a decision notice is in the public domain as well. So it also avoids the potential scenario where the council may forget to further down the line, particularly if information is submitted several years after, particularly in this case where there's a 5-year consent, it also would avoid the potential where the council may inadvertently forget to do that and involve that consultee. So that's really why that's been this has been added to conditions. Also, it is within the HOPS conditions as well, where it's the model conditions, where it actually includes in consultation with, and some examples are included in that as well. So that gives a little bit of a background as to why this is this approach has been adopted.
Okay. In terms of Mr. Hardy's concern there, aside from who is the statutory authority to discharge particular conditions, if, for example, a condition specifies a different body to be consulted and the discharging of a condition has to be made in consultation with whichever body we're talking about, if that body doesn't respond or won't respond or whatever happens there, how can the planning authority still then discharge the condition in compliance with its own terms?
Yes, with the approach we've taken, if we've actually consulted that body, and if they don't respond within a time frame, we would still have the powers to discharge the condition effectively in consultation with. It doesn't actually say anything within the condition in terms of that they have to respond. So the approach we've taken is if a consultee hasn't responded within the certain time frame that we've specified, then we can then go and agree a condition or discharge a condition. If we've consulted the consultee, we would have met the obligation of that condition.
Right. Mr. Wilson, thank you. And then I'm going to come to Mr. Brown. Sorry, Mr. Brown.
Thank you, Mr. Vaughan. Really just to agree largely with what Mr. Robinson just set out there. We can obviously consult anyone that we choose to consult, and that there is some benefit in having named consultees in a condition for the reasons set out there, where it may be a number of years down the line, if a specific consultee has requested that. Quite frequently it can be at a request that if the condition is not attached they may object, so it becomes a very important condition for that consultee to be involved in. However, I do also have a degree of agreement with Mr. Hardy in terms of it's not perhaps strictly necessary to always name the consultees, because ultimately it is open to the consenting body to consult whoever they feel necessary to be consulted. So to some extent, a foot in both camps there. We have a bit of different practice as an authority. We probably do both. We try and avoid naming it where necessary, but where it does have that very specific benefit of a consultee having specifically requested something, perhaps to avoid an objection, we would perhaps err on the side of
Yes.
caution and put that named consultee in the condition.
Thanks, Mr. Wilson. That's helpful. So presumably you could have a situation where you've got a condition where you've named a different consultee, and actually when it comes to it and you're consulting, you might actually think you want to ask more consultees than are actually specified in the condition.
Yes, sir, I think that's perfectly open to the planning authority to consult, or ministers to consult whoever they feel is necessary to gather the information appropriate to deal with that condition. So it's not necessarily restricted to the named consultee.
Mr. Brown, thank you, Mr. Wilson. Mr. Brown, could I have your views on this, please?
Yes, thank you, sir. I've perhaps got little to add to Mr. Armstrong's comments and Mr. Robinson's comments, sir, but the additional point which I would make is a technical one so far as the air navigation order is concerned in Article 222, and that is that if there is to be a change in the lighting system, and I'm happy to develop this in submissions without becoming overly technical about it today, if there is to be a change to the lighting system, the permission of the CAA will be required for that. And indeed, sir, the lighting report, which is referred to in the proposed condition, actually starts by making it clear that that report was prepared on the basis that the permission of the CAA was being sought. It's paragraph 1 in the executive summary, and the CD reference number for the document, sir, is CD 14. And indeed, sir, in that document at paragraph 8.9, that report, it specifically says that the specification of the transponder-based lighting activation system will be subject to consultation with and approval by the CAA prior to the commencement of the construction of the wind farm, if there's to be a change. And the letter from Andy Wells at the CAA, which is in the same CD reference number, sir, at paragraph 6, says, we note the intent to deploy a transponder-based lighting activation system. And then he goes on to say, we further note that the final specification of the transponder-based lighting activation system will be subject to consultation with and approval by us prior to the commencement of the construction of the wind farm. So against the background of how the applicant has approached this and the response from the CAA, sir, it would seem eminently sensible to have the CAA named in the condition. Now, so far as the airport is concerned, the airport does not lay any claim to having responsibility to agree or discharge a condition, but it's proposing that it should be named as a consultee as a sensible, pragmatic step, having regard to the mantra which you'll have heard regularly, sir, in the aviation session about safety being paramount. And I appreciate that no evidence was led on the transponder activated lighting system from a technical perspective, and it's certainly not for me to give evidence on that. But even if the system is approved by the CAA, there may still be local issues which emerge. And the airport, having thought about this in some detail, is concerned that perhaps an aircraft might contact the control tower, as it would be entitled to do, and say that their onboard transmitter, which would activate the lighting, had somehow failed, or it might receive a call from an aircraft to say the lights hadn't come on when expected. And the purpose of the airport being consulted in this is to ascertain and to share, first of all, the concerns which the airport might have about operational issues which arise, and to try to find a protocol which would allow those local operational difficulties to be overcome in a way which obviously meets the criteria of ensuring that safety is paramount. So that's the sole purpose of the airport's involvement here, sir. It's driven by safety considerations.
Right. Okay. Thanks, Mr. Brown. I've got a couple of questions about that. So in terms of if the CAA's approval had been received, is there a possibility that Glasgow Prestwick Airport would still be in a position where it wouldn't be satisfied with what was proposed, or would that rest on what the CAA's position was?
Well, ultimately, sir, if the CAA mandates a transponder activated lighting system, the airport will have to accommodate that. Obviously, it's not for the airport to countermand that, but there may nonetheless still be the local issues which I raised, sir, just at a very practical level. If the lights don't come on, how is that to be dealt with? Perhaps an aircraft has detected some fault in the lighting system, which should be reported to the applicant. It's very practical considerations like that, which might not be addressed by the CAA, which the airport has in mind.
Okay, and then in terms of the regulatory regime, so in terms of the CAA approval, presumably that's a separate process. So the CAA would need to approve it separate to any discharge of a planning condition. Is that correct?
That's my understanding, sir, under Article 222, paragraph 7, because it's not a standard lighting system. It's not a steady lighting system.
Well, I mean, that depends on which lighting system ultimately
Yes,
is brought forwards. But in terms of any change or any lighting system, that would need to be approved by the CAA before it could be implemented.
yes, sir. I'm happy to include a further detail in that in the submissions.
Okay, I think I've got what I need in terms of that point. Mr. Hardy, do you have any comments on what you've heard there over and above what you've already outlined?
Well, I mean, quite a lot there, but I don't hear anything with respect, which goes to the underlying analytical point, which I know you've got. I mean, it is worth saying. Obviously, we're in Scotland. I work in both jurisdictions. In England, of course, you'd never have another consultee. There is guidance about having, indeed, militating against having named consultees on conditions. It's the statutory discharging party. So all of those technical issues, whether that's aviation, radar, environmental matters, they're all dealt with in absolutely properly in these sorts of conditions without named consultees on conditions. So the big point is, would you be missing anything, risking safety or environmental harm? Absolutely not, because the condition is perfectly watertight. And in response to the point that's just been made by Mr. Brown, I didn't understand it, because that's a separate consenting regime for the CAA. There wouldn't be discharge of the planning condition in the planning system unless that had been done. So it isn't right to try and tie the planning system of discharge to a third-party consenting regime. Just as the same, you could make a similar point under IPPC or whatever it is. That's not right. And the third thing I'd say, and I was very grateful to East Ayrshire that recognises the point about necessity. I don't think it is necessary for these people to be named, but you could have a position where the authority feels as though it's heard enough from one of the named parties. So it's another sort of factual scenario that you didn't raise in your questions, and it could say, you know what, enough. We've got to take a balanced position based on technical expertise, but we've heard enough from you. You want to continue, and we know that you are not going to agree to this. And actually, it ought to be allowed to get on and do that, exercising its statutory function. So there's no harm. It's absolutely not required. It doesn't pass the test of necessity, and nothing that I've heard from my learned friends makes me change my view. So thank you.
Thanks, Mr. Hardy. On a separate point, on condition 6. So Mr. Brown mentioned there the transponder activated scheme that's been intimated by the applicant. My question is, should this condition or a different condition require a transponder activated scheme to be developed and implemented if it receives regulatory approval? Would that be appropriate? Sorry, you muted, Mr. Hardy.
Yes, we say that this scheme is acceptable in its own terms. So the answer is no.
Okay, that's your position. That's fine.
Thank you.
Are there any other comments on that particular point? Mr. Robinson, thank you.
Yeah, I take it transponder, are we talking about potential for radar activated lighting? Is that what we're referring to?
Essentially, yes. Sorry. So this was a discussion that was touched upon in inquiry session 1. So it basically would mean that the aviation lighting would not be on unless an aeroplane with a transponder was within a certain distance of the wind farm.
Yeah, my understanding and dealing with similar cases where this has been discussed is that such technology actually needs additional infrastructure to be implemented, such as construction of towers in the vicinity of the site to detect aircraft, and which would need planning permission in themselves. So the view that we've taken is that you can't attach a planning condition for that because of that additional infrastructure that is required. So really, it has to be assessed on the merits of the lighting scheme that is as submitted in the application.
Yeah, absolutely. That's very helpful. Thank you.
Great, thank you very much. I don't have any further questions on condition 6. Just keeping half an eye on the time, it might be appropriate point in which to have a short break there. I think we'll be able to make a bit of progress because obviously now we've discussed that question which applies to a number of conditions about the in consultation with point. We're not going to have to dwell on certain conditions for that reason. So can I suggest we have a break until 11:30, please? And if you stay on the call, so just conscious there's different faces again, so please don't leave the call. Just you can turn your video off and mute your microphone, and I'll see you very shortly. Thank you very much. Okay, welcome back, everyone. I'll just wait until I can see everybody before we recommence. Is Mr. Robinson back with us? Mr. Armstrong?
Yeah, yes, he is. He's just moving around the table back to his seat.
Great. Excellent. Okay, so we're now looking at the deemed planning permission conditions. So this is page 6 onwards of the revised schedule. Okay, so in terms of condition 1, the applicant has made an amendment which that clarifies the locations of the turbines and essentially the site layout linking to figure 2.1a. Mr. Armstrong, do you have any further comments on this condition, please?
We're content with that amendment and don't have any further comments.
It's helpful, thank you. I wasn't expecting anybody else to have any comments on this condition, but I'm just checking. Okay, great. So in terms of condition 2, I noted it's agreed and no comments and so on, but I just got one question, Mr. Hardy. In terms of part 2 of that condition, where it refers to the tip height shall not exceed 200 metres above ground level, would it be appropriate there to make reference to turbines 49 and 50 being no greater than 149 metres?
Yes.
Okay, Mr. Armstrong.
So we were obviously thinking the same point in light of the discussions this week, but we actually thought it would be better if you just had a full stop after the supplementary information full stop and didn't go into the specifics thereafter, and that it would be appropriate to just leave it with the reference to the documents.
Yep, happy.
Yeah, I mean,
happy
I
with
don't
that.
think there's any doubt. You're happy, Mr. Hardy? Yeah, because I mean, there's no doubt in the application as to what it's for. I don't think so. I think that would be satisfactory. Okay, great. Thank you. So then, condition 3, that the amendment just changes the format. So that aligns with East Ayrshire Council's suggestion. Mr. Armstrong, can I ask, do you have any points on that? You had the suggested tailpiece.
Yeah, I think in light of the change, we're happy with that now.
Okay, thank you. So condition. Couple of amendments to this significantly is the part 4 of the proposed condition. Mr. Armstrong.
Sorry, we lost you there, or at least I lost you. Your screen went blank.
Oh, did you?
Yeah.
Okay, right. Okay, I shall start again. So I'm looking at condition 4 on micrositing, and the proposed condition as updated in the last column on. So there's a change on page 8, which. So part 4 of that condition now is the most substantive change, and that indicates that there would be no micrositing of the specified turbines closer to the nearest 4 affected properties. So obviously that was a point that Mr. Campbell had made for Stop Sanquhar 2, so it would appear to address that particular concern. I don't want to touch on the in consultation with point again, as I indicated before. Can I have any comments on that amendment, though, please? Mr. Armstrong first.
Yes, sir. I mean, I think first of all, in light of the discussion earlier this week with Mr. Denny, and particularly in relation to what he said he had considered can we now align ourselves, well, we are now aligning ourselves with the East Ayrshire Council suggested conditions. In relation to the additional point, it is moving in the right direction, but I think if I hand over to Mr. Robinson in relation to that, the concern is obviously that was not making them any closer. That doesn't necessarily address the issues that were discussed earlier in the week, because it could just be moving them east or moving them west, or depending on north or south, can make quite a considerable difference. And if we hand over to Mr. Robinson on that.
Yeah, the reason we're looking at the topography of the landscape here, and obviously there's some areas that have quite significant changes in levels, where an additional 50 meters could have an additional impact depending on the landform, and just simply moving being allowed to move or restricting a turbine being closer to the property might not actually be sufficient in that regard. So based on the topography of the landscape, in this case, we feel that a 50-meter micrositing, which is a standard for other developments that we've dealt with, would be sufficient. And if it was any more than that was sought, then the applicant, of course, would have the opportunity to apply for a non-material variation, of which the council could consider under that process.
But there should be no micrositing.
But in terms of the properties themselves, I think it would be probably easier that actually no micrositing was allowed for those properties identified, and then a consideration could be taken as to the suitability when more information would be submitted as part of that process, if indeed the turbines needed to be microsited when the developer would come to construct the project.
Thanks, Mr. Robinson. So there are 2 points there. There's this question about the appropriateness of micrositing in any direction for the turbines which are closest to the properties, and there's a point there in terms of whether should that be more appropriately dealt with essentially by written agreement of the planning authority, of the relevant planning authority. Is that correct?
Yes, that's correct.
Yeah, and then in terms of the overall micrositing that applies to the whole site. Is that question as to whether or not 100 meters is appropriate, or whether a 50-meter allowance would be more appropriate? Mr. Hardy, do you have any comments on those points?
Yes, I mean, to a large extent, these are matters for your judgment, and you know, you'll take a view on the view on the evidence. In terms of the big point, whether it's 50 meters or 100 meters, 100 meters is perfectly proportionate for. These are large bits of kit, and no question. And 100 meters is perfectly proportionate in relation to, you know, unforeseen ground. Obviously, we've done work, but unforeseen ground conditions, water courses, all that sort of stuff. The stuff that you know about. So the overall movement, we say, is acceptable, and it won't, given the scale of these turbines, have a discernible effect on the landscape and visual impacts. That's Mr. Denny's view, because of course he assessed that micrositing tolerance. In relation to the properties, what we've tried to do is is look at the basic integer, to look at distance from the properties. We're not going to move any closer. We say that that's enough. If you move to the east to west, left to right, whichever it is, we say that's not going to have any discernible different impact in relation to residential amenity. But if you took the view that actually that was no micrositing for those specified turbines subject to an application, then that is a judgment call. We say it's not necessary. We think that the protection enshrined in in the newly inserted subclause 4, which I have to say has been put in a number of these conditions. It's just a general point. You know, we have listened, absolutely been responsive. It is in response to I thought, a fair point that was raised during the residential amenity session. So whether it goes far enough is a matter for you, but it is the client listening and responding.
Thanks, Mr. Hardy. Mr. Wilson, do you have any comments? Obviously, there are turbines which this is relevant to within East Ayrshire Council's boundaries.
Yes, sir. We'd obviously set out our position originally on the table that the 100 metres was excessive, and that was also in the council's committee report to our members when we took our decision not to object. So we feel that that's excessive. Mr. Robinson makes fair points there, and I'm happy to largely rest on them. 100 metres. I wasn't obviously party to the inquiry sessions on landscape and visual. But in my own experience of dealing with a number of different wind farm sites and also looking at designs with applicants, movement up to 100 metres of multiple turbines may not result in new significant effects, but it can result in quite a radically different design to a wind farm, and potentially resulting in effects that aren't particularly desirable, and it probably a lot of work was originally put in to avoid. So by reducing the micrositing tolerance down to 50 metres, which is the standard micrositing that we have worked with, we're not precluding anything beyond that, because it would be with the agreement of the planning authority, but it would give us the opportunity to consider the kind of potentially more far-reaching impacts that multiple micrositing of distance could potentially bring to the scheme.
Thanks, Mr. Wilson. Are there any final points on this condition before I move on? No. Okay. Thank you,
sir. Just from the airport's perspective.
Sorry, Mr. Brown.
Yes. From the airport's perspective, the condition as amended is acceptable to the airport.
Oh, that's helpful. I should have checked. Thank you, Mr. Brown. Yes, I'd assumed it would be on that point, but it's good to know. Thank you. Okay, so then in terms of condition 5, aviation safety, this is principally probably a discussion between the applicant and Glasgow Prestwick Airport on this point. So there's an amendment made which might be of some reassurance to the airport, but Mr. Brown, have you had a chance to review the change? Does that go far enough? Obviously it looks quite different to the condition that you'd proposed.
Yes, sir. I have had an opportunity to look at it and take instructions. It certainly takes us a lot further forward, and on that basis the airport no longer seeks to amend it in terms of lower Roman numeral 1, which appears on page 9. Lower Roman numeral 3 is fine, and lower Roman numeral 4 is fine. The one which remains an issue for the airport, though, is lower Roman numeral 2, which is confirmation of the blade construction and first rotation timescale. That's an absolutely vital date for the airport, because that's the date at which the optimization needs to be completed, or as soon as possible after that. I'm conscious, sir, that the condition as drafted now 1A provides that the airport will be notified along with others of the date of the expected commencement of each stage of construction, and it's not clear whether the blade construction and first rotation will be included in that programme under 1A. But if it's not, the airport would propose that it's made clear that if the dates of confirmation of the blade construction and first rotation are not included in the information to be provided under 1A, that the airport should receive 3 months advance notice of those dates. And that's to enable the airport to organise TERMA to deal with the optimisation process. They obviously just can't turn up at short notice. And normally that sort of information would be discussed between the airport and the developer during the regular progress meetings. And of course the airport saying in this case it can do without those, but there would still need to be a mechanism to make sure that the airport knew in sufficient time what the first rotation date would be, in order to organise Terma. There's one supplementary point here, sir, and that is it's not consultation with the CAA, but notification to the CAA. When the table was prepared with the airport's comments, the airport had included a condition that the CAA be notified of all crane activities. And I appreciate, sir, you want to take these in turn. I'm happy to deal with that point now, or if you prefer, sir, deal with it under condition 9. But it seems to me that if there is to be notification to the CAA, it's more appropriate that that is included in this condition rather than condition 9.
Okay, I'll keep that in mind as we discuss this.
Certainly.
It might be easier to come back to that point, but let's see. So in terms of the
Sorry, sir, I've noticed that Mr. Hardy's back.
Sorry, what was that, Mr. Brown?
I noticed that Mr. Hardy had disappeared from the screen.
Oh, had he? I was looking down. I haven't seen. He's back now. Did you hear everything, Mr. Hardy?
Interestingly, you all disappeared apart from.
Oh, hang on. That was a little bit. Yeah, hang on. So, Mr. Hardy, if you can hear us, you're currently
You say
disappearing.
Can you hear me?
Can you hear us
Can
now?
you hear? Well, I was saying, interestingly, you all disappeared and I was the only one left on the screen. So modern technology. Yes, I heard that Mr. Brown broke up, but I got I got most of it.
Okay.
In response, look, these aren't, I don't think, points of great moment. I think that it. Are you able to hear me
Oh,
still?
Mr. Hardy, we've lost you again.
Have you?
It
Is yours
broke up
broken
again.
down?
Can I just check? Is anybody else
Yeah.
having any issues? Nobody else. I think it might be an issue at your end, Mr. Hardy. That's not a. It's not pointing the finger. It's just so we know how to potentially resolve it. It might be worth.
Yes,
just
I'm in
trying,
my
if you can hear
offices,
me.
as probably is apparent. It's not something I can do very much.
Yeah, no, I know.
I'll tell you what I might do.
What I might suggest
Would it
is
help if I leave and come back in? How about that?
That's what I was going to suggest. Yeah, let's try that, because often that resolves things like turning off and on again. Always does. So we'll give that a try.
That's my default tip for problems with technology: just turn it off and then we'll turn it back on. Yeah.
We'd been doing very well, hadn't we, until that point today?
Hello. Is that?
That's looking promising so far, Mr. Hardy.
I was just saying that's my default behavior, is just to switch it off, switch it back on. It's if that doesn't work, if that doesn't work, you pay for the man to come round, don't you? That's what happens with me. Right. Not points a great moment. It doesn't seem to me. I think in answer to Mr. Brown's point, if you amended 1A to say which shall include blade construction, that will do. And in terms of the point about whether it's condition 9 or not, I don't think it, as long as it's done, it doesn't matter particularly. It could be done, the notification could either be done here or under condition 9.
And in terms of Mr. Brown's point, his point was around first rotation as well. Would it be appropriate to add that into 1A? So which shall include
I mean,
blade installation,
it's
first
an
rotation?
it's an email. Yeah, you see, the answer, yeah. Happy with that.
Mr. Brown, sorry, did you?
Yes, sorry,
want to
yes,
come back?
that's acceptable from the airport's perspective.
Okay, thank you. That's helpful. Are there any other points under on condition 5 which anybody would like to raise that haven't been addressed? No. Okay. So moving on. Okay, so in terms of condition 6, redundant turbines, it appears that that amendment would address the airport's comment, but does it, Mr. Brown?
Well, so it's a similar point to the one which I just made in connection with organising TERMA, that it's certainly progress to be notified of redundant turbines, but it would be better if the airport could be notified 28 days in advance, so that again it can make arrangements for TERMA to attend to de-optimise, if that's the word, the radar.
Mr. Hardy, would that be a suitable change?
Yeah, again, I don't think it's any great moment because you'd be planning removal of, I think, a turbine grade. But whether you do it slightly before, slightly after, don't think matters. 28 days would be within the programme, so we're happy to accept that.
Okay, thank you. Any more points on condition 6? Okay, so condition 7, this is the environmental clerk of works. So there's an amendment in the updated condition from the applicant. Which
yes, I think that was it. So East Ayrshire requested
Yeah.
reference to the ECOW in micrositing approval to be added to the scope of the duties. So we've added that in the revised proposed condition. We've accepted what EAC had to say.
And that was the only change suggested, I think, by East Ayrshire. Is that correct?
Yeah.
Yeah. So I assume there's not anything further we need to discuss there. Oh, okay, good. Okay, so condition 8, the planning monitoring officer. So the main point of dispute, I think, is whether or not this can be the same or should be the same person as the ECOW. And the councils have expressed a view that it shouldn't be. So if I can ask, or perhaps if we can ask Mr. Wilson and Mr. Armstrong and colleagues to set out their position on that first of all, and why they consider that would be inappropriate, please. Mr. Wilson.
Thank you. We've probably 2 points here in terms of the council's position. I know you're going to come on to legal agreements perhaps later.
Yeah.
Our initial preferred position would be that this would be covered by Section 75, where the councils appoint an independent planning monitoring officer and are reimbursed for that. So that's the first point. I don't know if you want to deal with that here, sir, or later.
I think actually, yeah, I think it would be helpful rather than separate it out because it's relevant directly to this particular condition and whether or not it should be separated out as a legal agreement. Let's deal with it here. Okay,
so as I mentioned, that's a preferred position. We do believe that it's necessary to have a planning monitoring officer as their preference is a legal agreement so that we can appoint the planning monitoring officer via the council. For the council's perspective, that brings true independence to what is an important role, and it's seen to be independent by the public as opposed to a developer appointed planning monitoring officer. We do as a council have experience of having both a council appointed and a developer appointed PMO on a site, and we found quite considerable differences in reporting with the council appointed officer. We found we're finding more instances of non-compliance and issues, and we're fulfilling their duties more thoroughly. So that transfers through to public confidence and using that person to rely upon for the planning authorities to ensure that there is that public trust that the developer is implementing their consent and doing what they said they were going to do. So that's essentially the first point, sir. And because it's a financial payment, we don't feel that that can be addressed via a planning condition. That would be contrary to the tests in the circular, hence why we've asked for a legal agreement to cover that. Our fallback position, if you don't agree with that, or if ministers don't agree with that, is that we do use the conditions. We do think that the condition itself is necessary, but we've asked for the two roles to be separated out. We see them as quite distinct functions. The ECOW has a set of duties that are placed on that role, and potentially to add PMO type duties onto that really blurs the lines about proper reporting and the role of each person. Now, it may be pointed out that it's meant in the wider term of it's the same company or so on that provides it, but again, you're asking us to rely on almost Chinese walls, and in reality, it's very difficult, I think, for those two roles to be properly set out so that we have the comfort that the planning monitoring officer is reporting independently and without any other pressures placed upon them because of the nature of their appointment by the developer. So that is the gist of our position. So it's a two-stage thing there.
Thanks, Mr. Wilson. That's helpful. Mr. Armstrong and colleagues, do you have anything to add or any different views on what Mr. Wilson's outlined there?
So we adopt exactly what Mr. Wilson has said in relation to the Dumfries and Galloway Council's position.
Okay, thank you. Mr. Hardy, please.
Yes. Well, I mean, I agree with the need for somebody to be suitably qualified, independent of the developer, and fit and appropriate person. So there's no question there. What conditions 7 and 8 expressly provide for both the ECOW and the PMO are just that. But there's no reason to suggest that a professional party fulfilling those roles, and it may be that this just get, we're able to deal with it in this way. Person or party doesn't have to be an individual. That can be a company. So in terms of a legal personality, that could be a company, and therefore it might not be the same person anyway. We're just saying it could be, might not be. So if people are fixated on the fact that it's one individual person, then I don't think that that's actually what the conditions require. I think the forcing the developer to have separate individuals, so actually to have two named individuals, adds cost for no good reason. In terms of the mechanism, there's absolutely no reason why a legal agreement is necessary. It can be conditioned, of course. Hops, there's a model condition, and there's guidance, obviously, in the circuit. If you can do this by way of condition, then rather than a legal agreement, then that's preferable. Not least in terms of saving unnecessary complexity, time, and money. And I think the final point is that this has been run a number of times before at Section 36 inquiries. I don't need to take you there, but in your leisure, you might want to look up South Kyle, Pen Clow, and those decisions. You'll see that a condition was imposed. So there's good precedent for doing it. The council's argued this before and not carried the day. So we're not objecting to the principle at all. We're endorsing the principle, agree with it, but it doesn't need to be it doesn't need to be amended in the way the councils are suggesting, and it can be done by way of condition.
And Mr. Hardy, in terms of the condition to require a planning monitoring officer to be provided, what do you see the benefits to the applicant being on having that planning monitoring officer in place?
I think it's that sense of third-party objectivity. So it's just having. I mean, it's not strictly necessary. I mean, there's lots of projects, multi-stage projects that where I see where you don't have a monitoring officer. there are some others, particularly waste and mines and minerals, where a PMO just typically is in place. So I think you'd have to satisfy yourself that it was necessary. But what my instructions are is that we're not, the client's not going to die in a ditch about it. And if that provides some transparency and objectivity, then that will be a matter for you to determine. But strictly, I don't think it is necessary.
And Mr. Armstrong, Mr. Wilson, do you have anything to add?
Well, obviously, we do think it is necessary, and I don't think there's anything further we need to add. I think we've just lost Mr. Hardy again. He's back.
Could you hear us, Mr. Hardy, then? Yeah, good. Okay. Mr. Wilson, anything to add?
No, nothing further. We've made our point now. Thank you.
Yeah, thank you. Okay, so condition 9, the construction and environmental management plan. So I've got notes all over this, so just bear with me a second. Okay, so I think, so if I can turn to, so Mr. Wilson again, so the main suggested change to this is around seeking a scheme for preliminary site investigation and ground investigation works to be covered under this management plan condition. Is there anything you'd like to add to other than what's before us? Do you want to say anything? Mr. Hardy, can I check you can hear us still? Could you hear us, Mr. Hardy?
I don't. We've been absolutely. I'm sitting in the same seat. I've been in 2 weeks. I don't know why it is being temperamental this morning. I heard most of that. Probably got the key parts of it.
Good. Okay. Yeah.
Do you want me to respond? Were you asking? What I didn't get was whether you were asking me to respond. But
no, not yet. I just asked
right.
Mr. Wilson if there was anything he'd like to add to what's set out.
Just in brief, Mr. Warren, just to advise that our practice has been to include this in any kind of large-scale project. It's also been adopted by ministers in the last 3 Section 36 decisions in East Ayrshire, and it's been quite successful in giving comfort that the works to establish our site investigation and ground investigations, that they are done in such a way as to not substantially affect the baseline, just recognising that it's a very large scale development, and that even SI and GI works can be quite disruptive. So it's, you could call it in kind of layman's terms a mini SEMP document, just to give comfort that those existing works to then inform the rest of the SEMP are done in a sensitive way that meets the principles of what the environmental information was seeking to do anyway. And the 3 decisions, sorry, if you wanted to peruse them, I think some may have been lodged, but certainly Penclow decision has been lodged, I believe, as a core document. And if you felt the need to see others, I can point you to that direction. But there has been 3 recent decisions on that have included that.
Thank you. Mr. Hardy, do you have concern with what East Ayrshire Council has proposed there? Or
yes.
Does it go beyond what's required?
Yes, it does. It's not necessary. And of course, there's a general position that we shouldn't be burdening development with unnecessary conditions. Everything's got it has to go through the prism of the test and the circular, and the council hasn't come up with any particular reason why a suspensive element to this is required. there is I think there's a note that the East Ayrshire Council does think that there could be an issue with private water supplies at the Craig, but that's dealt with dealt with elsewhere. So in terms of this part, there's no particularization of reasoning, and simply saying that it's been done in other cases. I don't know what was agreed and what was not. There may have been justification there, but there isn't here. Groundworks would be subject to best practice, of course. So it doesn't pass the test. It doesn't pass the test and could be potentially burdensome in terms of in terms of getting on.
Mr. Brown, in terms of the point which you wanted to come back to, this is obviously it. The in terms of crane activities. So I got a note when I was going through this yesterday, and I put down a question to ask you as to whether or not this point is kind of covered sufficiently by condition 5, but obviously that's not your view.
Well, sir, it's just a case, I think, of adding the Civil Aviation Authority to the list of people to be notified under condition 5, if the applicant's prepared to do that.
Okay, well, that would address that point.
Yes, sir.
Yes, and we're happy with that, sir. So that's fine. It's on the notification.
Great, thank you.
Thank you.
Okay. So then, sorry, before I move on, can I just check, is there anything else under condition 9 that anybody would like to raise? Mr. Wilson.
Yes, thanks, Mr. Warren. If I can just come back just briefly on Mr. Hardy's point about it being not necessary, I think he slightly makes the point for me by saying that best practice will of course be followed. The condition is necessary to ensure that best practice is followed and that's agreed. So I would only add that we do believe it to be necessary, and ministers have adopted it in three occasions, and obviously thought it was necessary for those sites. I do accept that sites can be different, but the principle I think is applicable to them all.
Thank you. So then, in terms of condition 10, this is construction hours. The amendment suggested by East Ayrshire Council has been included in the revised text. There's a question there in terms of Dumfries and Galloway Council's point here about HGV movements to and from the site. My question on that is that enforceable? So can HGV movements be controlled if they're on the public road? And that's to Mr. Armstrong and colleagues, first of all.
I'll pass over to Mr. Robinson on that one.
Thank you.
We would normally do this through the traffic management plan, and it's the same with agreed routes in terms of the abnormal load in some respects, where I suppose there's nothing to stop an abnormal load trying to use certain roads, but the traffic management plan would set out exactly which routes would be permitted to be used. So in some ways, I would say a lot of this would be dealt with under the traffic management plan, but there has to be in respect to this scheme, a lot of the local roads in this area aren't capable of accommodating the heavy goods, so there is a necessity for this, but this is in terms of timescales to protect amenities. So I would have thought that normally this would be dealt with as part of the traffic management plan.
Thanks, Mr. Robertson. We'll come to the terms of that management plan under condition 16 shortly. Mr. Hardy, do you have any comments on that so far?
No, we obviously accepted the amendments from East Ayrshire in terms of HG movements. We you need to look at condition 20 as well. But the points about whether you can actually condition that, so you've got they're well made.
Okay, I don't think we need to talk about condition 11. There's an amendment there to change essentially the format of the condition. So unless anybody indicates to me now, I won't pause at condition 11. Okay. Same for condition 12. It's the same points that we've already discussed. Okay. Same for condition 13. Condition 14 is agreed. I've not got any questions about that. Condition 15, again, the point about who should be referred to, we've discussed. I don't have any further questions. And in terms of condition 16, we came to it quicker than I thought we would actually. The construction traffic management plan. So here, Dumfries and Galway Council has got a suggested amendment or addition. And my question, Mr. Armstrong and Mr. Robinson, is whether or not these points are more fully covered already in condition 17.
That was our point. Yeah.
Right.
If you just give us a moment, we're just considering that
Yeah,
point.
of course. Yeah, no. Yeah, there's no rush.
Two points. So the second point is Sanquhar.
I think so. Mr. Robertson will come back on that.
Yeah, I can't see where in condition 17 it actually explicitly states about the details of the length, width, and access configuration. If somebody could point me to that, where that's included. And that's the information, obviously, that we've requested as part of the construction traffic management plan, so that we're aware of what and the reason for this is because of there's a lot of roads in the areas that actually have weight limits on them. So that's why our roads officers will be wanting the actual configuration as well, so that they can ascertain whether any abnormal loads can the actual road that's in place can actually take the weight of those vehicles. So that's the reason why that's being requested.
Can I help there, Mr. Robinson? 17 B So 17.1b, so detailed breakdown of abnormal load vehicle movements by type and month. That seems to me to do the job. However, if you wanted to open brackets, including length, length and breadth, then length and breadth of vehicular length and breadth, that will do. I'd have thought. Sweat.
Yeah, I'd accept that. I think it's just to add clarity for and some precision to the condition, exactly what information our roads officers are requiring. So,
okay, well, I'm happy with that. I'd have thought just parenthesis after type, and then to length and breadth. And was there another parameter as well?
There was weight, I think you mentioned, Mr. Robinson.
It says the length, width, and axle configuration. I think it also.
All right, that's fine. Then you can put those three into brackets. That I think that will do the job well.
Yeah, I'd agree.
Okay, thank you. I've got a note of that. Okay, so that takes us past 16 and 17. I don't think we need to speak about 18 or 19 or 20. 20, the amendment reflects the point made by Dumfries and Galway Council there, like the reference to the bank holidays and public holidays. Again, 21. Tweaking format. Just stop me if you want me to pause, but otherwise I think we're on to where I suspect we'll have a more lengthy discussion. Condition 22 and the operational noise condition. So prior to today, obviously East Ayrshire Council had indicated their preference to have cumulative noise limits included within the condition. And thank you for taking the lead on preparing the wording for that you were seeking. We've got the applicant's essentially response within the schedule here, which I won't read out. I'm sure you've read it. But if I could ask Mr. Wilson, first of all, is there anything you'd like to add or to highlight before I ask Mr. Hardy for his comments on what he's outlined in particular in this schedule?
Nothing significant, Mr. Vaughan, just to reinforce that we did take the advice of an independent noise consultant. When we...
Sorry, Mr. Wilson, just pause a second because I can see Mr. Hardy's. Could you hear okay then, Mr. Hardy? Oh, you're muted now, so I can't hear you. But
you were just taken away for a little bit, but then brought back.
I just lost you at the end then. But let's see how let's see. So Mr. Hardy, if you can hear me, your screen is frozen and you've now disappeared again.
So I see. It's really frustrating, isn't it? I don't know. So this is it. It's frustrating. Can you hear me, sir?
Can hear you now. Yes. Yeah.
Yeah. No, I'm sorry.
Mr. Hardy, I would suggest trying the same trick again if you can hear me. You're just logging out and logging back in again to the call.
I can do that.
Well,
I can also try. I could also try and move seat. I'm very sorry about it. I don't know why it's happening. But
no need to apologise. It's not your doing.
Well, what I might do is just.
It's turned into an action video.
Might be something as simple as the positioning of a metal girder. Sometimes that can interfere with Wi-Fi.
I think the girder still must be close to you, Mr. Hardy. It hasn't made any difference so far. I think try and if you can hear me, try and log out and rejoin the call. No, not consistently. Try logging out and logging in again like you did before.
Yes, okay.
That seemed to work for a period of time.
Yes. Can you hear and see me now?
Yes.
Ah.
You're also appearing twice.
Am I?
So your name is appearing twice, but I don't think that's a problem. Callum, if you're listening in the background, I don't know whether you can remove Mr. Hardy's unused box, or if it's not causing a problem, we can leave it. But
it's my secret doppelganger, my avatar. There's two of me.
There we go. It's gone. It's gone. Yeah, that happened. That happened when I rejoined. I think
Did
a few days ago. Right. Okay. So, in terms of where we were up to, so I just asked Mr. Wilson if there was anything further he wished to add or to highlight in relation to the operational noise condition. Mr. Wilson, do you have a concern that, or does the council have a concern that without the tables 3 and 4 relating to cumulative noise, there could be a situation where noise limits are exceeded at the receptor properties identified?
Essentially, yes, it does come down to that. But a large part of this is about attributing noise and being able to hold a development accountable if there is noise complaints. It's a complex cumulative situation in that area. Each development has its own limits, and as you continually add further developments into that complex cumulative noise situation, being able to ascertain who may be in breach of their noise limits becomes more and more difficult. So as I was mentioning just before, we have an independent consultant that we go to and ask about the noise submissions, and his recommendation is to use a cumulative noise condition, which will have standalone limits for the applicant to operate their wind farm to, but there's also the fallback of a kind of total cumulative type position, so that the most recent development takes responsibility essentially for the total noise, and kind of avoid the situation of planning authorities struggling to identify which wind farm is actually in breach of conditions. And whilst we go through quite protracted processes with potentially multiple wind farms, properties could be subject to noise levels that may be thought to be unacceptable. With this development being the latest in the line, they would be the one that would take that potential risk whilst that was investigated properly. So it sets a a separate total limit to ensure that that's not exceeded. That reflects the position and the condition that was accepted by ministers for the nearby Penclow wind farm. So essentially the wording and the style is pretty much identical to that accepted decision, with the tables updated to reflect the specifics for Sanquhar 2.
And I presume that the wind farms that are in the sort of part of that baseline that contribute to cumulative noise, they're all subject to individual noise limits themselves. I'm talking obviously just in East Ayrshire here. There's the same question does apply to Dumfries and Galloway.
I believe there will be. Each site should have its own noise condition. I obviously can't say for certain on the
No, that's okay.
For the East Ayrshire ones, yes, they all have limits of one sort or another, whether they be individual limits or whether, such as Penclow, they have individual limits and a cumulative limit.
And in terms of enforceability, obviously where you've got more than one wind farm contributing to the noise at a particular receptor location, there's in terms of meeting, assuming that there are individual noise limits at each location, there's a question as to how you attribute which of the wind farms individually is potentially exceeding a limit, presumably, as well as what the overall cumulative situation is. How would the council go about that?
To a large extent, you're driven by the condition wording for each of the wind farms, but a large part of it, and certainly no expert in judging a noise issue, but we would obviously, if we had a complaint from a property, we would seek to get as much information as possible from them about perhaps when the noise is adjudged to be unacceptable or there seems to be a problem. So we can perhaps narrow down which wind farm it may be. So if it's with reference to certain days or times, it may be possible to narrow down that they're downwind of a certain wind farm, and that if that wind farm is perhaps the closest, that's probably the first wind farm that you would look to investigate, because it's the most likely wind farm to be contributing to the noise, and you would go through the relevant investigation process with that wind farm. But as I alluded to, the difficulty begins when there are multiple wind farms, all in close proximity, and potentially it becomes very difficult to ascertain which wind farm is the one that should be investigated, at least as an initial stage to discount that particular wind farm.
Yes, I mean that's my question, I suppose, in terms of going out and monitoring is very challenging unless you have the ability to require each wind farm to shut itself down, and you can monitor what the individual noise emissions are from each wind farm separately. I don't know how that would play out in practice. I suppose my question comes on to, in terms of the cumulative noise limit tables. I understand obviously that is there to ensure that regardless, I mean, the receptors aren't necessarily interested in which wind farm is causing the noise disturbance. It's the noise disturbance itself that's the issue, and as long as it gets resolved, that might not matter. But there's a challenge there in terms of what are the practical steps that can be taken to resolve that issue. And you mentioned that the essentially the approach is that the most recent development takes responsibility. So that would apply in this case if those cumulative noise limits identified in tables 3 and 4 that you've presented were found to have been exceeded. The first step would be to essentially curtail Sanquhar 2. Is that
essentially
correct?
Yes? So that the amenity issue can be dealt with whilst the investigations continue, and obviously if there is a separate culprit, then that can be investigated and hopefully would come out of the investigations. But it brings a degree of responsibility to the most recent development to fit into the noise parameters that are currently experienced, so that, again, putting it crudely, each developer could turn around and point the finger at its neighbouring wind farm and say it must be them because I'm operating to my limits. and then the planning authority is left with, as a minimum, potentially long and protracted investigation periods, whilst residential properties are potentially experiencing amenity impacts that were thought to be unacceptable.
Okay, thank you. Mr. Armstrong and colleagues, do you have anything to add or any different views on what Mr. Wilson's outlined there?
Well, obviously, sir, the important issue here is that the noise remains within appropriate limits, and ultimately it is for the applicant to satisfy you and the Scottish ministers that that will be the case with this proposal, taking into account, obviously, the cumulative noise that is relevant. And so ultimately, it is up to the applicant to put forward a solution, an appropriate condition, which will ensure that the noise levels will be appropriate in each circumstance. I appreciate it is difficult in these situations. And perhaps Mr. Robinson can just say a few words about the sort of Dumfries and Galloway experiences.
The approach that this council's taken, we've basically referred to it as the later of the wind farms that comes into the system has to take the cumulative burden in terms of noise. I'm trying to think of situations where we've actually had this in terms of a practical example, and I suppose the best one to refer to is it's a scheme that Mr. Wilson will probably be aware of is the Lethans and Glenmuckloch schemes. Lethans is a scheme that is within East Ayrshire, and the Glenmuckloch proposal is within Dumfries and Galloway, and they're located pretty much side by side on the boundary. And the approach that's been taken in that case has been well, the most recent Glenmuckloch condition has actually got tables similar to what's been suggested by East Ayrshire Council. So you have individual daytime and noise limits, and then tables 3 and 4 are cumulative daytime and noise limits. And effectively, whichever scheme has become later, or whichever one received consent in the latest, is the one that would be investigated first, and that's seen as the fairest way and most practical way of starting any potential investigations if a noise complaint was to come. So the approach we've taken is very much of it's the latest scheme would take the cumulative burden, and that's the way that we've been approaching this.
Okay, that's helpful. And then, of course, the evidence presented by the applicant, and obviously Mr. Hardy will speak for himself in a moment, but the evidence presented by the applicant is that there is no cumulative issue at this time in terms of the Sanquhar 2 wind farm can be introduced to the cumulative situation, and there would be no individual or cumulative noise limits being breached. Is that, in terms of the individual noise limits, I'm assuming that there's no alternative views to that? I haven't heard anything expressed.
No, we're content with those limits that have been advanced.
Okay, Mr. Hardy, it's a bit to go on there. Would you like to respond?
Yeah, what I've heard is a lot of sort of generally informed comment. Can I put it like that? Noise is obviously a technical discipline. I've got a lot of experience of dealing with cumulative noise and conditions, and as have Hayes Mackenzie, who are the noise consultants, and I'm sure you'll be aware of them in relation to other schemes over the last 20 years. This isn't, a situation. I understand the general point that people might make. Oh, there's different wind farms, but actually, you have to look at the particular circumstances of this case, and the points I'd make are these: that what you're looking at is control and protection of amenity for individual occupiers. That's what this is about. It's not some sort of general conceptual safety net based on we're slightly concerned. It's about protection of individuals. And here, the noise limits for the proposed development in isolation ensure that cumulative noise levels are acceptable. So in other words, baseline plus what you've got. So the tables 3 and 4 which are floated are irrelevant if if the derived limits in tables 1 and 2 are met. So including cumulative limits offers no additional protection to residents. So the limits are the limits, and if they're met, they're not tables 3 and 4 aren't serving any purpose. So it isn't about, at heart, are you going to risk additional noise nuisance for occupiers? Absolutely not. And cumulative noise conditions are more about commercial apportionment of the noise burden. So in other words, between developers scrapping over who has to turn turbines off, you don't have that situation here. So the controlling noise limits are those for the on the solus effects on the properties. So it's not required. Secondly, in terms of necessity, so the applicant agreed the D&G condition effectively, which is having worked alongside Hayes Mackenzie. So D&G are raising, I think I took it to be a general observation really, rather than moving away from their stated position. But D&G's condition was accepted. But in terms of East Ayrshire, they employed AECOM to look at and review the noise assessment, and they agreed that the derived noise limits for the proposed development would result in cumulative noise levels that were acceptable and accepted the principle of governance through the solus effects anyway. So the technical advice to East Ayrshire on this particular scheme is that the cumulative tables are not required. So there's no basis applying the actual tests for the condition. There's no technical basis for imposition of cumulative noise conditions in this case at all. Everything that's been said is, as I say, based on a sort of general concern and a kind of nebulous worry. But that doesn't apply. Yes, it can apply elsewhere, but it doesn't apply in the Sanquhar 2 situation. So you don't need it.
Thanks, Mr. Hardy. Mr. Wilson, is there anything you'd like to say in response before we move on?
Yes, thank you. Just to clarify that we did obviously take that advice from ACON UK, and their conclusions, they did actually recommend that there would be a cumulative noise condition, and that document has been specifically lodged by the council as support of this position. So they suggest that should be there, and the specific reasons where that condition should approve the efficacy of the investigation and resolution of any valid complaints concerning turbine noise from residents potentially affected by the wind farm. So just to clarify, that was actually the advice of our experts, that a cumulative noise condition would offer best protection.
Obviously, I've read that report, but that's on a precautionary basis. The actual finding was that there was going to be no breach. So I put that in the category of a sort of precautionary, concern, whatever else. But it isn't necessary in relation to protection of residential amenity, which is what we ought to be concerned about.
I only make the point of we agreed to disagree on that it's since included in the report. I did acknowledge that the ACON accepted the specific levels that were put forward, but this was a additional and thought necessary level of protection.
Thank you. Okay, I'm going to move on from operational noise. So in terms of condition 23, I'm just keeping an eye on the time as well, because we want to break shortly, I think. So I'm going to, if there are easy things we can tick off before lunch, we'll do that, and then we'll resume. So in terms of condition 23, this is decommissioning, restoration, and aftercare method statement. So I think the point made by Glasgow Prestwick Airport here appears to be addressed in condition 25. Mr. Brown.
Yes, that's correct, sir. Although when we get to 25, I will have a comment on the proposal.
Okay, thank you. And then in terms of the comments, the alternative wording proposed by Dumfries and Galloway Council, does this essentially replicate condition 25 and condition 23?
I think yes. I mean, so the D&G, the proposed condition, so it incorporates the requirement to submit a detailed decommissioning, restoration and aftercare plan 3 years prior to decommissioning into this condition. We've separated that out into condition 25. And then the council was adding a requirement for a species protection plan based on survey for protected species, including birds, to be carried out no longer than 18 months prior to submission of the plan. And then third thing, there was some consultees added.
Yes.
Cutting to the chase, our response is it's more effective to have separate conditions in respect to the pre-commencement approval of decommissioning, restoration, aftercare method statement and a detailed decommissioning, restoration and aftercare plan, which we put in condition 25. The required actions are separated by about 37 years, and that approach allows for clear discharge of condition 23 rather than having a partial discharge under the single condition. So we say that's why it's better to have it separated out. There is no disagreement over the substantive obligations. It's a timing point. We say you should split them out rather than have them as a composite. And then the applicants added in the requirement for species protection plans under condition 25. So
Yes.
it's about form, not substance. There's the reason why we say you should separate them out.
Mr. Armstrong and Mr. Robinson.
It's Mr. Robinson. I'll address this one.
I agree. I'm actually not sure why we've done that. No, our normal practice is separated out for that reason, because you have the strategy first, and at least then that can be discharged, and then the separate condition comes after when the development is coming to the end of its life. So no, it should be separated out to accept that point.
That's very helpful. Thank you.
Thank you. Yeah, thanks. So there's nothing on 24. So on 25, Mr. Brown, you indicated you had a comment on it.
Yes, sir. Thank you. It's the same point as was made in relation to condition 6, that the proposed condition here in 3, so far as the airport is concerned, is the developer will provide the airport with notification of removal within 14 days after any such removal. And again, as I say, it's the same point, that notification in advance.
Yeah, happy. Yeah.
Yeah.
Happy with that, Mr. Brown.
Right, thank you. And that's the same period of 28 days.
Yes.
Yes. Thank you.
Thank you. I wonder whether that might be. I know we're tantalisingly close to the end, but I'm conscious sometimes it can be a false economy to try and push on, and it might. I don't want to do what's remaining a disservice. So I'm actually going to suggest if we take our lunch break now, and then we'll finish off what's remaining after lunch if everybody's agreeable to that. I don't know what your thoughts are in terms of whether or not you want to continue. It can be quite tiring looking at things in forensic detail, so I don't want to get less from it. All happy? Okay.
So yes, perhaps one point that it might be helpful for Mr. Hardy to consider over this break, that when we're discussing these conditions and looking back at the environmental statement, that there isn't a condition on television and radio reception, and that was in part based on what's set out in the environmental statement, and the understanding in that all television and radio, or all television reception, it's now digital in this area. I wonder if Mr. Hardy could just consider the issue of perhaps having that condition over lunch, particularly in light of what is actually set out in the environmental statement. And Mr. Robinson's got the paragraph of the statement in particular, I think.
It's the EIA report, January 2019, in section 13, and section 13.4 deals with TV reception, and particularly paragraph 13.4.5 acknowledges if there is a detrimental loss of TV reception, the developer will investigate the interference and rectify accordingly. But they sort of make the point that they considered that most of the, in their view, although it isn't given with any real evidence, that the properties in that area are digital services. So it's just we feel that it would be beneficial to have this condition on, particularly that the applicant has stated that they would investigate any interference if that arose, or if any complaints of that arose.
I'll certainly give consideration. I have to say that is a condition which over the 20 years I've been doing wind farms, that has what was important and now isn't, for this reason. Digitization has taken away that as an issue, and in fact post the switchover, I even when that's been imposed, I can't recall a single instance where it's actually been called upon. So there is a judgment call, and that cuts both ways. You could say, well, look, if it's not going to be called on, then it's no skin off the, a developer's nose, put it on. I think it would have to satisfy a test of necessity, and I appreciate what's in the EIA. My experience elsewhere is that is not required because of the technological change, and it may be that that's a reference, that's a hangover from previous sorts of studies, which when it was analog was more important. I'll take instructions. I suspect, I mean, it's a fairly standard condition if it was going to be imposed, but I think you'd have to, it comes down to necessity. So whether or not in the digital world you consider that to be necessary. Obviously, I can't give evidence. You'd have to work on the basis of what's in the EIA, but I'm just giving the benefit of, in practical terms, digitization has taken that issue away.
Okay, let's come back to it as you say after lunch, to give it some thought. So if I can ask you to be ready to restart at 1:45, please. I suspect we may need another hour and a half potentially to complete proceedings. Thank you very much. Welcome back, everyone. Good afternoon. Okay, so we were up to condition 26, I believe. We were just turning to the financial guarantee condition on page 22 of the updated schedule. Now, the applicant here has made some amendments to their proposed condition in response to some of the comments made. There's a more substantive point here, I think, in terms of the point of East Ayrshire Council, which I know that Dumfries and Galloway Council support. That's in relation to whether or not a Section 75 agreement should be in place instead of this condition, or as well as this condition. I was wondering if I could ask Mr. Wilson and then Dumfries and Galloway Council to comment on their position, please, Mr. Wilson.
Thanks, Mr. Warren. Yeah, we set out in the comments and also in the kind of hearing statement document that we put in that a preferred position would be that a legal agreement and a condition is used in this case. There's nothing in law that we're aware of that prohibits such an approach, albeit we know that it's not encouraged through the circular. But for such an important issue, we feel that gives the council and the environment and communities the best possible protection for such an important matter, to ensure that if there was any failures or any problems, that there's a acceptable guarantee there for the council to call upon and to use whatever enforcement powers are necessary, whether it's through the condition via the planning acts, or whether it be through specific implement in court of a legal agreement. Our kind of fallback position thereafter is that the Section 75 would be our preferred position if you're not with us on using both. We have pointed out that Scottish planning policy does support the use of an obligation at paragraph 169. It's also supported in the HOPS document that we've submitted as well, which that document itself also has Scottish Government sign up to it. So we believe that there is policy support for a legal agreement on this matter. Ultimately, if you don't agree with that, our kind of final position obviously is that there's a planning condition would be necessary, and we've advanced comments within that table that we think protects us as best we can within the realms of what we can do with a planning condition.
Thanks, Mr. Wilson. And in terms of the shortcomings of a condition in terms of enforceability, what's your principal concern there?
It's not so much about the initial guarantee. It can be fairly strong in terms of that you would expect to have that for your initial guarantee, and you can look to things like enforcement notices and potentially stop notices at that point. I think a lot of the concern for our council comes when you then look to replace the guarantee as it's updated and refreshed throughout the time. It's much more difficult if there was a breach of condition at that point, because the planning acts don't ultimately compel any requirement to put that in place. It can be criminal type processes where there's maybe referrals to court and different things, but it doesn't necessarily get what we want out of it. And the use of a stop notice, as you'll know yourself, there's tests associated with that, and if the wind farm is operating and on the face of it seems to be working and it's fine, then we would find it difficult to be able to serve a stop notice to achieve that, to ensure that there's a replacement guarantee in place. So this is about, from our perspective, having the full spectrum of powers that a planning authority could potentially call upon, and we do draw on our experience here with the failures of the open cast coal sector. East Ayrshire was particularly badly hit. There was a lot of lessons learned in this council through investigations by the former chief planner at that time, and recommendations about how we take things forward, and that's been the council's position for a number of years, and that's the argument that we advance in each case.
Thanks, Mr. Wilson. Mr. Armstrong and/or colleagues, please.
Sorry, if I could start by just saying that we adopt the position of East Ayrshire Council on this, but Mr. Robinson will deal with it in a little bit more detail and also refer to CD 902, which is the supplementary guidance in the Local Development Plan 2, and in particular paragraph H45 of that, which deals with this issue. Just on the wording of the proposed by East Ayrshire Council in relation to the condition, we'd suggest now that obviously it should be, now that we've accepted that there's two conditions here, it should be condition 23 and 25 and not just condition 23. And I think it should also probably be appropriate to slightly change that wording to restoration and aftercare obligations contained in and approved under conditions 23 and 25, rather than just saying contained in condition 23. So I think it should be contained in and approved under conditions 23 and 25. And if I could hand over to Mr. Robinson in relation to the supplementary planning guidance.
Yes, paragraph H45 on page 27 of supplementary guidance references section 75 and other legal agreements. There's also, and in particular, it refers to required restoration. In terms of more detail on legal agreements and bonds, it's paragraph S1 on page 29, which states that for medium and large turbine developments, these will be subject to the applicant enter into legal agreements to address the following matters, of which restoration bond and also television and radio reception is referenced. So it's effectively, the preferred method is the section 75 route. That's in accordance with our statutory supplementary guidance.
And this is presumably predicated on the potential financial risk to the authority in terms of if there was a failure of a bond to be secured sufficiently, then the bill would effectively be picked up by the councils. Is that right?
Yes, that's correct.
Mr. Hardy, what's your comments on this, please?
Well, of course, this is not about no bond at all. That argument, I think, would obviously be listened to if there was a choice to be made about bond or not. But it's not. It's just a mechanism for it. It's absolutely standard practice to do it by way of condition, and the arguments have been, run in various Section 36 inquiries. With the ministers imposing a condition. I think if you wanted some good reference points, then there's South Kyle and there's Pen Clow. There are others, but those are two. There are two good ones. Why? Well, control shouldn't be duplicated in conditions and planning agreements. That's the argument about whether you should have both. The circular says, well, look, you should do it by way of condition rather than a planning agreement where there is a choice. And the HOPS working group also recognise that it can be conditioned. I think the reference there is section 2, page 5. In addition, the working group agreed that planning conditions can be used to require submission of a financial guarantee. Enforcement, I don't understand. Effective enforcement mechanisms exist perfectly well under a condition. There's the full armoury there. And there are difficulties through from personal experience or dealing with clients in relation to legal obligations. That's not necessarily straightforward either. So our view is that there's a greater range, or certainly suitable range, of enforcement mechanisms. Then there are some minor points about the about proposed changes to wording. They are, I think, less moment. If we were going to, if you go down the wording of a condition, you looked at the EAC's additional text as in terms of the requirement to submit any replacement bond at least 28 days prior to expiry of a bond. We could accept that, and if required, I think we'd also be prepared to accept that references to the guarantee could be changed to the guarantee or replacement or successor document, whatever you want to say. But in terms of that's those kind of minor drafting points. In terms of the principle, absolutely clear. This is a condition point. It's not section 75 or doubling up with both.
Thank you, Mr. Hardy. So, Mr. Robinson, on that point, in terms of, so Mr. Hardy said it's standard practice to use a condition for this purpose. Is it standard practice in Dumfries and Galloway to use a condition or a legal agreement? So I appreciate the reference you've taken me to in the supplementary guidance.
We've actually had both. We've got them tied down by legal agreements. In some recent appeal decisions, we have had them attached by conditions as well. So we have had both mechanisms in terms of this issue.
Okay, that's helpful. Mr. Wilson, from what you said, I suspect that might not be quite the same in East Ayrshire.
The position is if we are approving a development, it will be a Section 75 legal agreement and a planning condition, and we have a number of sites that have that. But it's also true that there are sites that only have a planning condition, either through an appeal or via by ministers. So there are examples within East Ayrshire that only have a planning condition, but that wasn't the position advanced by the council.
Okay, right, that's clear. And then in terms of what Mr. Hardy said laterally, then in terms of the additional text to potentially bring forward into the amended proposed condition, do you have any comments on that?
I just generally welcome the commitment to potentially word it in the kind of style that we've advanced there. We feel that that's a stronger condition that better meets the tests of the circular and gives us a bit more comfort than the one that was originally advanced.
And Mr. Armstrong and colleagues, on that last point.
Yes, our preference is obviously for the East Ayrshire Council proposed wording as amended by my suggestions this afternoon.
Okay, thank you. I don't think I need to ask anything further on that. Thank you, unless there's anything else from anybody. Okay, so the next condition in the schedule is the additional condition proposed by East Ayrshire Council in relation to private water supplies, specifically within East Ayrshire. I can see the terms of it there, Mr. Wilson, so I don't need you to tell me what they are now. My first question, though, is are there any other regulatory kind of regimes that provide a fallback or safeguard for private water supplies?
It's not something that I'm the expert on myself, Mr. Warren. Normally revert to environmental health colleagues, but there certainly is legislation in relation to private water supplies, albeit I think a lot of the onus is on the user of the private water supplies as opposed to anyone else. The council has duties to monitor certain supplies, so as far as I'm aware, it's having it controlled through this condition would be an important element to ensure that the supply wasn't adversely affected, or that we would understand if it had been. I'm not aware of any substitute legislation that would adequately do the same job.
In terms of the kind of residual uncertainty about the potential effects on private water supplies, is there anything specific? I appreciate you're not an expert on private water supplies, and I don't expect you to answer questions that are technical in nature. But do you know Do you know where that residual concern has come from specifically?
I believe that's set out in the applicant's own additional environmental information. The consultants that produced that undertook various assessments and so on, and recognised that in their own document that there remained some ambiguity about certain elements, albeit they obviously felt that there was sufficient information that it didn't require monitoring. The advice from our environmental health colleagues is that that ambiguity was enough, that given the high sensitivity of the receptor, i.e. the private water supply, and humans using that supply, that it should essentially be a more cautious approach to ensure that there is monitoring in place, and if it was identified that there was a problem, that some form of mitigation could be advanced.
Thank you. Mr. Hardy. Thank you.
Yes, well, not necessary. It doesn't pass the test, leaving aside the availability of other controls and legislation on the facts here. It isn't necessary. The ambiguity isn't related to the conclusion that no impact due to infrastructure being on different hillsides to the PWS with no opportunity for hydrological connectivity. The conclusion comes from there being no opportunity for connectivity of the infrastructure and the recharge. So you've got to read that paragraph from the supplementary PWS memorandum carefully. And that wording of that reference to ambiguity as to what's meant. So the lack of hydrological connectivity, we say, gives you sufficient comfort that you'll find it that it not to be necessary.
And in that memorandum, are the paragraphs numbered? And if so, which?
It is
which
paragraph.
was it?
It's CD 3003089, and I've just got a note of that, of what's in it. I don't have that document in front of me, but I'm sure we can give you a paragraph number if you need it.
No, that's fine. I will read it and find it. So thank you.
I'm told that it's the last bullet point in table 1.
Okay, thanks. Yeah, I won't go to it now, but I will read that and form a view. And just check. Does Dumfries and Galloway Council want to add anything on that point? I appreciate you saying no comment. Right, okay, thank you. Okay, so that brings us to the end of the schedule itself. There's the point that was mooted before lunch about television and radio reception. Mr. Hardy, have you considered that?
Yes, really, as before. Obviously, I can't give evidence. I'm not going to. Or like what I was trying to do is give some context, which I thought would be helpful. You've got to decide whether it's necessary and whether there's information saying that it's necessary. I don't think you have that. What's in the EIA is a sort of precautionary, well, you might do this, but that's not the same thing as having positive evidence to justify it. All that having been said, clearly you've got to be satisfied, and if you were wanting wording of a condition to consider, then no doubt that could be put forward. It's tricky. I mean, we could do with that, I suppose, in closing submissions and give a suitable wording, and then you could go away and think about it. I mean, cutting through it, so I don't know whether you are sufficiently inclined to that, you know, in the next week or so we try and form some agreement with the council or not, or whether you're just prepared to say, well, look, you make your submissions on it, and then I can attach a model condition if I think that's fit. It may be that's a proportionate way of dealing with it.
Yeah, I'm not going to indicate a view on it now. but I'm conscious there is a model condition available.
Yeah. But why don't we do with it in, so if we put our respective positions in submissions, the council can do that if indeed it's pushing for a condition, and then you could look at a model, and if we wanted to make any amendments to the model, we could no doubt just suggest those in our closing submissions and leave it there.
Okay, and Mr. Robinson, sorry, Mr. Robinson, you when you were answering my last question about the financial guarantee, I think you made reference as well to the supplementary guidance, making reference to legal agreements in relation to TV and radio reception. If I heard you correctly, was that right?
That's correct, and the same applies for TV and radio reception. And we've had this tied down by a legal agreement and in conditions recently in appeal decisions, and we've got a condition that we can suggest that we've had recently, and also on Section 36 schemes that have recently been attached as well. I think our slight concern is obviously, given the rural nature of this area, it would have probably been useful if Mr. Campbell's witnesses who live in this area could have confirmed or not whether they have digital television. My experience of being on site visits in that area is I don't think the digital radio exists. So I think it would make sense to include the condition, because the EIA doesn't really confirm either way. But it does make the offer of doing mitigation if required.
Do you want to refer to the example?
And in terms of the example that we've got, we can email, but effectively it's in 3 stages. The condition requires.
Sorry to interrupt you, Mr. Robinson. Mr. Armstrong, I think you might have your speaker on. I think I'm just getting a bit more echo again. Thank you. Sorry to interrupt.
Yes, so the condition that we generally attach is in 3 stages. The first one requiring a television and radio mitigation plan to be submitted to and approved by the planning authority. After that, if there's any claim from a person within the locality that has a loss of interference, then it's within the first 12 months, so it would only be for a 12-month period, then that has to be investigated by a qualified engineer. And then the third stage of such a condition would effectively require the developer to repair such any impairment that is found. And that's generally the structure of the condition that we would normally request, and has been attached, and we'd be happy to supply the wording of that if that would be helpful.
Yeah, I think it would be helpful to see it, and obviously Mr. Hardy can give his view on it. So I think I know what Mr. Hardy's view is. I don't think it will be changed from what you've described, but I don't know if Mr.
Well,
Hardy
no, just
wants to say
a technical point. I mean, TV was digitized in 2010. There is no analog TV.
Yeah, I was actually going to ask that question. I thought in terms of television, it is digitized. Radio obviously is both. So yeah, there's a question as to whether or not the TV element is still relevant. I don't have the technical knowledge to know whether there's any potential at all for digital television to be affected, but I'm not aware of
I
it.
difficult exactly. I don't want to give evidence, but no. I mean, is the response to that, and it has been the case. The digital switchover took place 11 years ago, so it's all TV is all digital in the UK, including remote parts of Scotland.
So this is a radio issue.
Yes,
if it's an issue,
if it's an issue at all, yeah. And obviously, people will have. I'm not saying everyone's got a digital radio, but a lot of people do. So, or internet radio, because that's the other point in terms of technology, that people who've got broadband. One of the things that was evident from the local residents is that they might not have phone signal in the remote areas, but I think it was Mrs. Coulthart, I think, or Mr. Hall, who said that what we do have is, no, Shinlehead, I think, wasn't it, who said that they've got that they brought, you got broadband.
Yes,
yes. Yeah, what that brings, of course, is internet radio. So actually, you aren't reliant. If you've got Wi-Fi, then you've got the ability to get internet radio. So I really don't see it as an issue.
Okay, I don't think I need to ask anything further on that point. My final question is it's an open question, I think, and it relates to the three properties in Sky Glen that the applicant has acquired. I'm mindful there's no occupancy restriction of any kind proposed in the schedule of conditions, and it was a question to consider whether or not that was something I should be considering, if it's appropriate to consider, and if indeed, would it be necessary if it's appropriate? So my reason for my questioning there is that part of it's obviously based on some of the assessment has been kind of taken out of the equation on the basis that those properties will stay empty if the development takes place. But as it stands, if the applicant had a change of heart on that position, or if indeed the property's changed ownership, there would be nothing stopping them, as far as I can see, them to be occupied. So, Mr. Hardy, do you have any initial reaction?
We were going to raise this anyway, actually,
right.
as a topic, or sort of under the heading of any other conditions, because we obviously have listened and reflected on what's gone, you know, what's been said this week, as you would expect. And where I'd got to was the potential for a condition which secured a provision of a maintenance schedule. So it seems to me there are two separate issues. One concern was the idea that you might have dilapidation, so that if properties were empty, that there might be a sense of dereliction for 40 years. And I understand that, because appearances can give, give the appearance of, if things are unkempt, then they look abandoned and so on. So the obvious way to deal with that, and indeed you heard evidence from, I think it was Mrs. Hall, was it, who said, or one of the witnesses from Sanquhar 2 had said that she'd met the joiners. I don't know whether you recall that, but she'd
It was Mr. Colthart.
Yeah.
Yes.
Yeah. So my memory's right, that she'd met joiners going to the property. And the reason for that is that the properties hadn't been abandoned at all. Actually, there's been work done on them because they were actually in a reasonably poor state of repair. So the developer has, done some work to make them, watertight and in better condition. So where we got to, in order to deal with that sense of dereliction, that there could be an obligation, whilst the properties certainly are in the ownership of the operator of the site, the developer, that they be kept up, that they be painted and they be kept in a position where actually there are no signs of dereliction. So there could be house, garden, boundary treatments could be kept and maintained. So it seems to us that that's a condition, could be a scheme to be approved, and we've got some wording that we've been kind of thinking about. We may be able to circulate that, not this afternoon, but maybe in the next week, and that would be just a scheme of maintenance. Within, I don't know, 6 months of the date of first export, something like that. There's a scheme of just to show how and when the properties will be kept up. So that, I think, would be a way of countering that point about dereliction. Second thing is completely different. That's the argument about occupancy and whether or not you want to control anybody moving into the properties, and that it's a different matter. I mean, there is I think a distinction to be drawn between properties which have a wind farm imposed on them, or that properties where the people are, owner occupiers have a property and then a wind farm comes along, and then those situations where actually there isn't anybody living there, a wind farm is built and then they're put out to the market, because it was at that point somebody renting a property or buying a property does so in full knowledge of the full effects of the wind farm. And of course here they were assessed in the original RVAS. There are no overbearing effects. It's not so it's not that they would be unsuitable for, or they wouldn't fail a public interest test. I'm not saying that's no indication of that people are going to move back in, or indeed that they should, but it's just that there is I think a difference for a wind farm where you have a wind farm that's built and then people move in after. So you could seek to control that by a condition in which doubled up with the maintenance provision for a scheme for any future occupation, or alternatively it could be that there's to be no permanent occupation. So I think there are things that you could do, and that rather depends on the what the genuine planning grievance is. If you were going to say, well, look, you don't think people should live there in the public interest test, well, there's a way potentially of putting putting in something in a condition to that extent. So we have. I'm just getting a kind of news flash from the client, and they are telling me that they would be happy to accept a condition, as I understand it, saying that there's no permanent. If you felt that, that was what you were seeking to achieve, there could be a condition that there would be no permanent occupation of those properties. If I'm just turn to my left, is that? So I think the message is, if that was the concern, and it was to an extent that you felt that was an appropriate control and the evidence you've got, then the client would not resist that. So that would be a maintenance schedule and potentially a condition saying no permanent residential occupation. And it seems to me that if you do that, that would be a balance then, because you are dealing with that sense of dereliction, but you're also then protecting residential amenity that you don't think ought to be, or people that perhaps oughtn't to be in the properties, if that's your view.
That's helpful, Mr. Hardy. In terms of the no permanent occupation point, do you mean no occupation or potential holiday use, for example, in terms of it's not a permanent dwelling, permanent residence?
I think what the limit of it, and it seems to me this is quite a good idea, is that there is, in order that the buildings aren't just completely empty for 40 years, there may be a suitable opportunity for workers. So for the site, for engineers, for refuge, for people coming to service the site, there may be occasional overnight needs, and if that is a way, isn't it, of having some use from the property. So is that, thinking aloud, is that residential occupation? Is that residential occupation, workers' accommodation? It probably is, isn't it?
I think I need to think about on that.
But
yes.
what you could do is you could carve that out, couldn't you? You could open, X other than. So you could say no residential occupation other than temporary, temporary workers' accommodation associated with the site, or something of that sort. Or permanent, or you could do it the other way around. You could say no permanent residential occupation. You could do it that way around, and then that would allow site engineers and turbine engineers to go and to stay overnight instead of going into a hotel in wherever it was.
And presumably that would potentially allow use as well. I'm not indicating whether that's a good or bad thing, but it's just as a matter of fact.
I hope you've gathered from what I'm saying. I'm not being prescriptive. What I'm saying is that there are different ways of cutting this, but it did seem to me that the two concerns were avoidance of dereliction, which I think we can deal with that by way of a maintenance and keeping up regime. That's fine. Then there's a separate question of whether you seek to you know, either have nobody there at all, or alternatively, it might be a good thing to have a few people in there to keep them lived in as houses and, you know, put the heating on every, you know, month or whatever it is. And that might be service engineers or Vestas or whoever it is coming, or not, you know, coming to service the turbines. And it is a fairly remote area, and it would make sense, it seems to me, in line with what I've seen at other sites, and I have seen this, where, you know, bad weather refuge, you know, people just, as I say, people coming from the electrical engineers having somewhere to stay on site rather than having to go to a hotel. But if you felt that even that was tricky and it was going to be no occupation, then the clients, I think, would be happy to accept it.
Okay. And in terms of, I'll open this up in a moment for to hear the views of others on that suggestion or those suggestions. My question that then springs to mind is, there's ifs and buts here, but if I was minded to say, well, actually, in the event of granting consent, it might be appropriate to allow occupation, whether it's permanent occupation or not. There's then the question of noise limits, which then come back into it in terms of, well, actually, do we need some noise limits specified for these properties as well, or would that be dealt with in some other way?
There, the noise limits are in there for those properties. They're in the assessment.
Are they? Oh, right.
Yes.
Okay. For those 3 properties.
Yes.
Excellent. Right. Okay. So that answers that question.
So, and they're
Thank
at
you.
they are at suit compliance, and noise is not, wouldn't be the constraining factor.
Okay. Yeah, I haven't paid a great deal of attention to the properties on the basis of them essentially not being occupied. So that's helpful.
That's understandable. Yeah.
Mr. Armstrong and Mr. Robinson, obviously these are within Dumfries and Galloway council area, so I'm not going to come to Mr. Wilson on this. What are your reactions to that conversation?
I think Mr. Robinson will address these points.
Firstly, just to confirm, it's the 3 properties are Dalgona, Polgown and Shield. And just,
Yeah.
I think that's correct.
Yes.
None of those properties are actually in the red line boundary of the site. So at this stage, I don't think that a condition could be enforceable. They don't fall within the red line boundary. And whilst I accept that the applicant has ownership of those properties,
Yes, there's ownership and there is ownership and control.
But that wouldn't stop if consent was to be granted. That wouldn't stop the developer potentially selling these on at any point. And I don't think that could be controlled as part of this of such a condition at this stage. So we do have some concerns about how such a condition would work in practice at the moment, and whether it could actually really be attached to this consent. And obviously there has to be a reason for attaching these conditions, and I'm presuming it's because the reason being is because there's an amenity issue to these properties, either in terms of noise or visual impact, and that's the reason why such a condition is being proposed.
Not really. I mean, there was a history. I don't know whether you were there in relation to these properties had been already on the were already on the market. People were struggling to sell, and so I'm not going into all the the evidence again, but I think it's trying to deal with objections which were raised by local residents during the week. If in fact the council says, look, you can't do that for various reasons, or we don't want to see that, well, then the council's position is that it doesn't want a condition and it remains as it is. And of course, the applicant is very happy with that. What we're actually trying to do, and I hope the point is made. The applicant is actually trying to do something and listen and respond constructively. So that's the spirit. We're actually offering something in order to, that maybe thought useful. If it's not, and the council doesn't welcome it, then we won't. I mean,
and on that specific point around the red line boundary, it is they are outside of the red line boundary. I'm just looking across to my plan. Yeah, I mean they are obviously outside. Is that an impediment to the condition? Or...
No, because it's blue land. It's ownership and control of the same applicant. So the condition would bite just in the same way. You don't need, in other words, in order to have an imposition of a condition, it doesn't need to be in the red line. It's just got to be land under ownership and control of the applicant, which it is.
Mr. Robinson.
My
Sorry.
colleague, Mr. Ferguson, is going to just say a little bit more on this matter.
Okay, that's fine. Yeah, thanks. Mr. Ferguson, aye.
Thank you, sir. Mr. Hardy is correct that if the land is within the control of the applicant, then in theory it's possible to apply a condition. However, for practical purposes, and Mr. Robinson referred to the possibility of the properties being sold, it would be almost impossible for a purchaser or even a tenant of these properties to do any research to establish whether or not conditions attached to their property. There is always a difficulty in imposing off-site conditions, even on blue land. Now, if it was land immediately adjoining the wind farm for, say, habitat mitigation or some such, that's one thing. But for practical purposes, how would a condition imposed as part of the deemed planning conditions here, how would a purchaser or a tenant of the individual properties become aware of that restriction?
I think the answer is that it would be until the point of disposition. All I can say is that there is no intention to. I mean, I would say this, wouldn't I? But there is no intention to sell, dispose, rent, or permanently dispose of these properties. But I think the condition could only bite up until the point that it is disposed of by the applicant. And I agree that that's limited. All I would say is that it is better to have that than not. And at that stage, if you were going to sell, then of course it gets back to my point that at that stage the wind farm will be operating. Somebody would be buying that on the market, with all of its, kind of in full knowledge. And there are people who want to live close to them, and there are people who want to live close to wind farms. There are people who aren't bothered, and so on. So at that stage, the properties would, if that eventuality came to bear, then they would just be people living in houses close to a wind farm. So I think the condition, you're right, it would be limited in terms of enforceability to the point of disposition. But our suggestion would be that, particularly given there is no aspiration to do anything with, the properties other than keep them, that it might be a useful temporary position to have, and I can't put it any higher than that. The alternative is no condition, so we'd be happy with that as well. So
there would be a third alternative of a planning obligation applied to the individual properties, which would ensure that the restrictions endured beyond the sale. Just as a mechanism.
Yeah,
that
potentially. I mean, I could take into. I don't think that. I think we have been quite clear in just wanting to avoid for policy-driven reasons, not just because for any lesser reason, but keen to avoid Section 75. So I think the instruction I'm hearing is that happy to have a condition in order to address those points, and it would be then met with that limit up to the point of disposition. I think that's where it would go. And if that's something that's useful, what we could do is circulate that in as a draft condition in the next week or so, or alternatively we can put that forward, in closing submissions. I think that's less satisfactory in a sense, because it may be that there is group effort. It may be that there's some good comments that can come from the other parties this week. So if you were content with that, so we might circulate one in the next 7 days.
Yeah, I think my preference would be to see something and to allow others to comment on it.
Yeah,
I think that
all
would
right.
be
Well,
helpful.
we can do that. We'll say that the other things are going out within 7 days. I think that's the fourth item that we're due to do within 7 days, and then perhaps 7 days after, then the other parties, if they wanted to have something to say, could come back to you on it.
Yeah. So thank you. And what I was going to ask now. I was going to ask probably principally Mr. Robinson his view on what may be the most kind of preferred outcome for those properties. But actually, I think rather than put you on the spot and say, well, they shouldn't be occupied, or maybe some holiday let, or actually occupation might be fine, perhaps see what Mr. Hardy outlines first, and you can outline your thoughts on that in your response. If I could ask you to do that, that would be helpful.
It's like
That's absolutely fine.
a sort of envelope, isn't it, of a condition with square brackets, because actually whether it's, you know, full occupation, it actually could be added, and people may have different views on that, but the overarching nature of that condition will set out, and then it'll be for others to decide where on that scale they would prefer to see the you know, to see the occupancy. So we'll do that this week.
Thank you. Okay, are there any, that brings us to the end of the schedule and the end of questions that I had in relation to conditions and the legal agreement. Are there any other points that anybody would like to raise? No. Seeing a definite no from everybody. Okay. Well, that, as I say, that concludes my questions. So before I close the inquiry, as discussed at the pre-inquiry meeting and confirmed in my note of that meeting, closing submissions, we touched on it this morning, are due by no later than the 19th of November from any parties wishing to lodge them. And the applicant's closing submissions are due by no later than the 3rd of December. It's perhaps worth me putting a marker down now that I don't intend to allow any extensions to these deadlines. So I'd ask you to do your utmost to meet those deadlines, please. We've got the 4 points from this morning, which I don't need to reiterate now. So we've got them as essentially action points to take forwards. Before I close the inquiry, are there any other applications? Okay, in which case, I'll thank you all for your ongoing input and participation in the inquiry. Many thanks for all your time. I now close the inquiry. Thank you very much.
Thank you.
Thank you, sir.